Morning. Let's come to order, please, and go on the record. My name is Frida Hilburn, a hearing examiner with the North Carolina Utilities Commission, and I have been assigned to preside over this hearing. I now call for hearing docket number W-1034 sub 13, which is in the matter of an application by Water Resources, Inc., hereafter applicant or WRI, for its authority to adjust and increase rates for water utility service in Rocky River Plantation subdivision in Cabarrus County and Riverwalk subdivision in Mecklenburg County, North Carolina. On December 29, 2023, WRI filed an application with the Commission seeking authority to increase its rates for providing water utility service in the Rocky River Plantation subdivision, hereafter Rocky River, in Cabarrus County, and the Riverwalk subdivision, hereafter Riverwalk, in Mecklenburg County, North Carolina. On January 3, 2024, WRI filed an amended application. On January 22, 2024, WRI filed a letter with the Commission updating the proposed effective date of the rates requested in its amended application. The applicant provides water utility service to approximately 115 residential customers in the Rocky River service area and approximately 39 residential customers in the Riverwalk service area. On January 30th, 2024, the Commission issued an order establishing general rate case and suspending rates, which declared this proceeding to be a general rate case and suspended the proposed new rates for up to 270 days pursuant to North Carolina General Statute 62-134 and 137, respectively. On March 1, 2024, the Commission issued an order scheduling hearings, establishing procedural and filing requirements, and requiring customer notice, which is the scheduling order. On March 6, 2024, the Commission issued an errata order to correct one omission in the scheduling order related to the filing date of the applicant's pre-filed direct testimony. On March 7, 2024, WRI filed its certificate of service indicating that customer notice had been provided as required by the Commission's March 1, 2024 order. On March 14, 2024, WRI filed the direct testimony of Dennis Abbott, president of WRI. On March 25, 2024, the public witness hearing was held as scheduled at the Mecklenburg County Courthouse in Charlotte, North Carolina. On April 8, 2024, WRI filed its verified report of Dennis Abbott for WRI on customer testimony. On April 12, 2024, the public staff filed the affidavit of Gregory J. Reger, Public Utilities Analyst with the Economic Research Division, the testimony in exhibits of Evan M. Hauser, Public Utilities Engineer, Water, Sewer, and Telephone Division, and Lynn Fiesel, Public Utilities Regulatory Supervisor with the Accounting Division. On April 22, 2024, the public staff filed its verified response indicating that the purpose of the public staff's response is to provide the results of the public staff's review of WRI's verified report regarding the public witness hearing and the public staff's opinion on whether WRI's responses adequately address the customer's concerns. On April 26, 2024, the Commission issued an order granting extension of time to file rebuttal testimony. On April 26, 2024, public staff filed supplemental testimony exhibits of Evan M. Hauser and Lynn Fiesel. On April 29, 2024, WRI filed the rebuttal testimony of Peden and Perry Consulting, LLC, and Dennis Abbott. On May 6, 2024, the Commission issued an order requiring filing of supplemental verified response to customer concerns. Also on May 6, 2024, the public staff and WRI jointly filed a list of witnesses scheduled to appear at the expert witness hearing on May 13, 2024, as well as the estimated cross-examination times. On May 8th, 2024, the public staff filed a motion to excuse public staff witness Gregory J. Reger from attending the evidentiary hearing. On May 9, 2024, the commission issued an order granting motion to excuse witness. That brings us up to date. Will the parties please announce their appearances, beginning with the applicant?
Hey, Police Commission, my name is Edward Finley, Raleigh, North Carolina. Appearing on behalf of the applicant, Water Resources Incorporated.
Okay, thank you, Mr. Finley.
Good afternoon. I'm Gina Holt with the public staff here on behalf of the using and consuming public.
Thank you, Ms. Holt. Are there any preliminary matters that we need to address before we begin this hearing?
Yes, the parties, as you know, were unable to settle all of the issues in this case, but in an effort to expedite this proceeding, there are some issues that are not in dispute. And we would like to bring that to the commission's attention at this time.
Very well, that would be good to hear.
Okay, and I will just read those into the record. The parties, Water Resources, Inc., and the public staff, North Carolina Utilities Commission, agree that the following issues are not in dispute. The rate of return. Water Resources accepts the public staff's position on the appropriate rate of return to be afforded WRI in its Rocky River and Riverwalk subdivisions. As to maintenance and repair for public storage, Water Resources agrees with the amount of maintenance and repair for public storage as calculated by public staff witness Evan Hauser. As to miscellaneous revenue, the company agrees to the miscellaneous revenues as calculated by the public staff's witness Lynn Fiesel. As to administrative and office expense, the company agrees to the administrative and office expense as calculated by the public staff witness Fiesel. As to insurance expense, the company agrees to the insurance expense as calculated by public staff witness Fiesel. As to miscellaneous expense, the company agrees to the miscellaneous expense as calculated by public staff witness Fiesel. As to amortization expense of CIAC, the company agrees to the amortization expense of CIAC as calculated by public staff witness Fiesel. And finally, the company agrees to public staff adjustments to test year water usage as filed by public staff witness Hauser. And that completes our list.
Mr. Finley, are you in agreement with that list?
Yes, ma'am.
May I ask, just for our clarification, the company in its rebuttal testimony lists its issues on beginning on the bottom of page 2, and it continues on to page 3. And it's actually a bullet list of the items that they are providing their rebuttal testimony to address. And I don't have them counted there, but there's a number of them there. Did the items that you just listed cover any of these contested items listed on pages 2 or 3 of this rebuttal testimony?
I don't believe so. No.
Okay. All right. That's what I thought when I heard.
Contention.
Okay. I was just making sure before we got started that we didn't miss anything. Okay,
List and the company's rebuttal testimony are still in contention.
okay, all right. But thank y'all for settling on the ones that you did. I'll help. I'll help at this point. So, okay. Is there anything further before we begin? I do have one question then. Mr. Finley, the commission did issue an order last Monday requiring a supplemental verified response to the customer concerns expressed at the hearing. This was addressing the public staff's report that was filed earlier, the previous week. The commission requested that, in particular, that WRI address Highland Ridge Homeowners Association statement at the hearing regarding the implementation of online billing and payment processing. And the commission was expecting that report on Thursday, so the public staff could respond. And one more thing before you respond, if you don't mind. And the company was allowed also in that order to address any other concern now that they had read the public staff's report, and they didn't have the transcript, I think, in time to go into the detail that they wanted to in their initial report. So those two items, the company was given opportunity, or I guess the first one, the company was given a requirement, but the second one was an opportunity for the company to respond, if you'd like to address that.
Well, we asked the commission's indulgence, so we've been so busy trying to talk and get ready for this case. That deadline has been passed, and we apologize, but we'll try to get that report to you as quickly as we can.
All right, would the company want to address that from the stand today, or would you prefer to file something later?
We will talk at the break, and perhaps we can do it from the stand.
Okay, all right, you can let me know. Okay, with that, we will proceed with the applicant's case. Thank you.
Excuse me. How would the commission anticipate the public staff's opportunity to respond to that report?
If the public staff is prepared to respond once they hear it live on the stand today from the applicant, that would be fine. Or if they would prefer to file a late filed exhibit, that would be fine as well. You can let me know after we see how things proceed today.
Okay.
And I'll clarify before we start, we have hearing examiner Jenny Lee here today in training. As y'all know, she represented the commission at our public witness hearing. And so she is here in training today. We are not a panel, but we are working together on this case. All right, Mr. Finley, we'll let you proceed.
The applicant will call Mr. Dennis Abbott to the stand, please.
And I will swear you in, Mr. Abbott. If you will come forward and place your left hand on the Bible and raise your right hand. Do you solemnly swear that the statement or testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
Yes, ma'am. Is that good?
Yes, sir.
Mr. Abbott, will you state your name and business address for the record, please?
Dennis Abbott, 6201 Fairview Road, Charlotte, North Carolina, 28210.
And what is your position with Water Resources Incorporated?
I'm president of the company.
And on March 14, 2024, did you cause to be pre-filed in this docket testimony and question and answer form consisting of some 17 pages?
I did.
Are there corrections or additions that you would like to make to that testimony at this time?
One correction. On page 8, line number 1. Need to make a correction where it says in 2021 and change that to in December of 2018.
Are there any other corrections or additions?
That's it.
All right. And if the questions they were asked of you today, would your answers be the same?
Yes.
Madam Hearing Examiner, we would ask that Mr. Abbott's direct pre-file testimony be copied into the record as though given orally from stand.
Without objection, that will be allowed.
Have you prepared a summary of your testimony, Mr. Abbott?
Yes, sir.
Okay, go ahead and read that, please.
In my testimony, I described the steps Water Resources has taken to comply with the Commission's order issued in our 2018 rate case and address compliance efforts for DEQ requirements and consent judgments required reports. I explained the steps the company has taken to obtain customer feedback and improve communications. I described the information the company provides with respect to quarterly customer contact logs. I maintained that the company has complied with requirements listed by the Commission in its January 29, 2022 order. I explained the steps that were taken by the company in response to the disconnection of well number 1 as a result of high levels of radium from the groundwater and the steps taken by the company to make the interconnection with the town of Harrisburg. I described the delays the company experienced in making the interconnection and the reasons for them. I explained that the interconnection ultimately has been approved and activated. I report that while well number 1 was not in service, the company did not experience water supply outages due to having only one well. I described the efforts taken by the company to respond to the requirements of the Division of Water Resources between the time that well number 1 was taken offline and the interconnection with the town of Harrisburg was activated. I provide a summary of proceedings before the Cabarrus County Superior Court to monitor the company's progress in remedying the absence of the second well. DEQ required that WRI explain delays in its effort to complete the interconnection with the town of Harrisburg. WRI has adequately explained to DEQ and the Superior Court the reasons for the delays and the justification for them. The result has been the withdrawal of any fines and a conclusion that there will be no sanctions to the company for the delays that it encountered in making the interconnection. I explained that the completion of the interconnection with the town of Harrisburg at a cost in the range of $470,000 is the primary factor driving the company's request to increase its rates in this docket and the reason for the timing of the request.
Does that complete your summary?
It does.
Mr. Abbott is made available for cross-examination.
All right, thank you. Ms. Holt?
Good afternoon, Mr. Abbott.
Good afternoon.
I would like to, in order to not exhaust a lot of time, I'd like to pass out my intended cross-examination exhibits ahead of time.
Yes, yes, thank you.
Mr. Abbott, I'd like to direct your attention to your testimony. Do you have it before you?
I do.
Okay. On page 7, beginning on page 7, you recount how you initially had 2 wells, and 2 wells are necessary in order to be in compliance with North Carolina Administrative Code, and you list Title 15A and other subsections. And specifically, you're required to have 2 wells if you're going to serve more than 50 or more connections, correct?
Two water sources, yes,
2
ma'am.
water sources. And as you go on page 8 of your testimony, in December of 2018, the company became aware that there were elevated radium levels in one of the wells.
That's correct.
Now, you did not take that well offline right away, correct?
I did take it off well, but not officially, but we didn't use it from that point forward. In fact, it had been inactive for almost 4 years prior to that. And the only reason why we were testing it is because DEQ changed their position and required us to bring it back online.
Okay. when you took it out of service officially, you knew that would trigger a violation.
Yes, ma'am.
You were in violation.
Yes, ma'am.
And that this violation would subject public health risk to your customers.
No, ma'am, I wouldn't say that I agreed that it would put public health at risk. We still had an alternate well, and in fact, the well was taken offline at the suggestion of DEQ. It was their suggestion that we go ahead and officially take it offline with the agreement that they understood that we would be in violation of that state statute requiring 2 sources of water.
Right. But notwithstanding that, when you agree that it was also the understanding between the company and DEQ that you would have an alternate source.
What they agreed was that they would give me time to work through an alternate source and find an alternate source of water supply, correct?
Right, but in order to be in compliance, you had to have an alternate source. You had to have 2 water supplies.
That's correct.
Okay. Now, let me go back to your answer regarding public safety risk. Isn't the basis for this rule to prevent or to ensure that the public is not at risk? There's no public health risk for consumers?
It's not a health risk. There is a risk that if one well goes down and you don't have the alternate, that there wouldn't be adequate water supply. We have an elevated storage tank of 100,000 gallons on the property that would provide water supply, reserve water supply for approximately 2 days in that situation, which should have been enough time if the well did go down for some reason to repair it. So the conversations with DEQ, we felt that both parties felt like the risk was very minimal.
Minimal for how long?
I'm not sure I understand the question.
The risk was minimal indefinitely?
No, again, because we have a 100,000 gallon elevated storage tank that can provide water supply without pumping any water for approximately 48 hours, depending on the usage in the community. The conversations with DEQ was that they believed that that gave adequate time if the pump went down on the well, that we could repair and replace it before there was a loss of water, the customer's experience of loss of any type of water.
Right.
That was the thought. If it extended beyond 48 hours, then certainly there will be a period of time that the folks were would be out of water.
So I think you state that you engage in page 8 of your testimony, lines 13 to 19, you informed North Carolina DEQ that you were going to take the well out of service after several months after you detected radium in your wells. And you presented a plan of action to install a new connection to the town of Harrisburg, correct?
That's correct. Yes, ma'am.
Okay, that's August of 2019.
Yes, ma'am.
Now, in February 6, we're jumping ahead. February 6 of 2021, because you had not found an alternate source, you, DEQ fined you or issued a penalty against the company for $4,500, isn't that correct?
Yes, ma'am.
Okay. Now, the company didn't appeal this, did it?
No.
Okay. And although the company didn't dispute this fine, it didn't pay it either.
No, ma'am. We were in conversations with both DEQ and the Attorney General's office through my attorney at the time. And all parties agreed not to pay. At that point in time, we would wait until such time as the interconnection was resolved, was finalized, and then we could decide on any type of penalties that needed to be paid at that point in time.
Okay, when did these conversations take place?
Right after the penalty was assessed.
Right after February 6, 2021.
Yes, ma'am.
Okay. All right, well, let's look at the timeline of the actions filed against WRI by Department of Justice.
Okay.
The Department of Justice Attorney General's office filed these actions on behalf of DEQ, correct?
Yes, ma'am.
Okay, and I might say DOJ as an abbreviation.
Understood.
Okay. I'd like to direct your attention to public staff cross-examination exhibit, public staff Abbott cross-examination exhibit 1.
Okay.
I'd like,
You have that to your left there, Mr. Abbott. You have that to your left there.
Oh, okay. Thank you. I was waiting for somebody to give us.
okay. Madam Hearing Examiner, that exhibit has been passed out and it has been marked. And it's entitled, Mr. Abbott, for your reference, Complaint and Motion for Injunctive Relief.
Mhm.
And it was filed on June 18th, 2021. Are you familiar with this document?
I am.
Okay.
Ms. Holt, do you want to enter these into evidence one by one as you as you get started? That might be
Yeah.
smoother for me, if you don't mind. Okay, so we are going to mark, without objection, we are going to mark this first exhibit, Public Staff Abbott Cross-Exam Exhibit 1. It'll be so identified as it is marked.
Okay. Now, Mr. Abbott, again, this complaint and motion for injunctive relief. Would you accept, subject to check, that DEQ can bring actions for injunctive relief whenever a person violates the Drinking Water Act or rules adopted thereunder?
I would.
Now, on pages 5 through 8 of this complaint and motion for injunctive relief, there are several factual allegations made, beginning with paragraph 11 on page 5, page 6, page 7, on into page 8, comprising 23 factual allegations made by the DOJ in conjunction with this complaint against company. Isn't it true that the company never took issue with any of the factual allegations
No,
in
ma'am.
this complaint? Okay. Now, paragraph 13 states, paragraph 13 of the factual allegations on page 5 states that on December 17, 2018, the PWS section, Public Water Supply section, sent an NOV to WRI for violation of the combined radium standard in one of two wells, well one, during the period of January 1, 2018 to December 31st, 2018.
Correct.
And it also states that on September 17th, that would be paragraph 18 on page 6. That the company requested additional time to return into compliance.
Correct. Because we weren't able to engage the town of Harrisburg in direct conversations, nor were we able to secure the easement that was necessary from the homeowner. And we thought we were going to have to start condemnation proceedings against the homeowner.
Okay. Now on also on page 6, paragraph 19, one of the factual allegations states that on November 21st, 2019, based on your September 17th request for additional time, DEQ extended the time for which the company needed to be in compliance from June 30th, 2019 to September 30th, 2020, correct?
Yes, ma'am.
So that's about 18 months.
Yes, ma'am.
They're giving you 18 months to comply.
Yes, ma'am.
Then the allegations of this motion state on page 7, paragraph 20, on September 21st, 2020, less than 10 days before the September 30th deadline for coming into compliance, defendant or Water Resources claimed that the new connection could not be constructed due to the company's inability to obtain an easement.
That's correct.
Correct.
Mhm.
Now, my interpretation of this is that the DOJ emphasized the less than 10 days. The company had 18 months to perform this, yet waited just 10 days before to inform DEQ. Was that timely in your opinion?
No, I would say your interpretation is incorrect, because what this report doesn't reflect is there were ongoing and continuing conversations between my attorney and DOJ on what progress was being had. We were providing DEQ with regular updates, quarterly updates as to what the status was, what had been done. And so while that does say that in the report, that's not reflective that we didn't do anything, nor that we didn't communicate with them on a regular basis, because we did.
But nonetheless, they filed this injunction,
That's correct, because
which
that's
alleges
correct.
that they didn't know until 10 days before.
All I can tell you is that we gave regular reports and there was ongoing conversations. I can't speak to why they would put that in the report.
But it's not in the report, and it's a factual allegation which was not controverted.
But it's my testimony of that there was conversation going on.
So you're saying that this is inaccurate?
No, ma'am, I'm not saying that.
Okay,
I'm saying there's additional information that's not reflected here.
okay. I'd like to now go on to folk staff's next cross-examination exhibit. It's entitled Consent Judgment. And Madam Hearing Examiner, I would like for this to be marked as Public Staff Abbott Cross-Examination Exhibit 2 for identification.
Okay, without objection, that will be allowed. It will be so identified.
Mr. Abbott, are you familiar with this judgment?
I am, yes, ma'am.
And this consent judgment was signed on July 15th, 2021, correct?
Yes, ma'am.
And it was signed by you.
Yes, ma'am.
Now, this consent judgment on page 5, paragraph 16. Could you read that into the record?
Sure. As of the date of entry of this consent judgment, defendant has failed to implement the plan set forth in the August 12th and August 17th, 2019 status reports. The public water supply system at the Rocky River Plantation subdivision continues to operate using only one well and no other approved water supply source. And defendant remains in violation of North Carolina's drinking water regulations set forth at 15A NCAC 18C.0402 G5.
Thank you. And then on page 7, paragraph 8, the last sentence, could you read that into the record?
Defendants, you're talking about where it says defendants?
Yeah.
Okay. Defendants' continued noncompliance exposes residents of the Rocky River Plantation subdivision to significantly elevated public health risks.
So a minute ago, earlier in our conversation, you stated that you didn't believe that your noncompliance presented an elevated public health risk, correct?
Correct, I did.
Do you still maintain that position?
From this perspective, I think it's an interpretation of what is a public health risk. If there was a risk of not having water supply, if that poses a public health risk, then yes, there was a risk of that. But there wasn't a risk of contaminating water, providing any type of water that was not acceptable for drinking water. So that's what I meant when I said earlier, and I think I stated that, yes, there was a risk for them not to have water supply if the well went down. So from that perspective, if that's a health risk, then yes, it does pose a health risk. But from a contamination of any water, no, there's no health risk. So I appreciate you letting me clarify.
That's your interpretation,
Yes, ma'am. That's what I meant earlier.
but that's not what the law says.
I'm not a lawyer.
Okay.
Yeah.
On, if you turn to the next page, paragraph 11. Could you read that paragraph into the record, please?
The parties expressly waive any argument that the recitation of the above findings of fact and conclusion of law is insufficient to support the injunctive relief order below.
So in light of this statement, which is in the consent judgment, which you signed, you're, in essence, the company admitted that the allegations that were in the initial motion for injunctive relief were valid.
There were-
Objection, that's not what it says. It says it waives any argument. It doesn't say it agrees to that.
It waives any argument.
Waives any argument.
So you could not refute the allegations in the injunctive motion, correct?
Correct.
Thank you. So this consent judgment basically, between DEQ and WRI, you reach resolution on the injunctive relief thought. It held it in abeyance, if you will, until you comply.
Correct.
Okay. So according to this consent judgment, the company agreed to file a compliance plan, right?
Yes, ma'am.
Okay. And the company agreed to various milestones and engineering certifications and things like that, right?
Yes, ma'am.
And the ultimate goal was to have the interconnection with the town of Harrisburg completed by September 9th, 2022, correct?
Yes, ma'am.
Okay. And that meant everything being done.
Yes, ma'am.
Right, I'd like to now direct your attention to it has a cover page dated September 12th, 2022. And Madam Hearing Examiner, we'd like to have that marked as Public Staff Abbott Cross-Examination Exhibit 3.
Without
for
objection,
identification.
for identification, that will be marked as identified and accepted into the record.
And Mr. Abbott, this is, if you turn to the next page after the cover page, it is entitled A Motion for Entry of Order to Show Cause for Civil Contempt. Are you familiar with this document?
I am.
And it was filed on September 12th, 2022. Correct?
Yes, ma'am.
And that's 3 days after WRI was supposed to have the interconnection constructed,
Yes, ma'am.
completed.
Mhm.
Okay. And you would accept that this motion to show cause for civil contempt was filed because WRI had not met its deadline to finalize the interconnection, correct?
Yes, ma'am.
To not even begin construction, correct?
Well, define construction.
Anything.
No, that's
Yeah,
not
got
true. Well, I mean, to do a construction project, you have to have engineering, draw up plans, you have to have surveys done, you have to have easements, you have to have contracts. And there was a lot, some of that work that had been done. And efforts made to get that work done. And you got to remember, we're also in a pandemic at that point in time. Everything shut down during a lot of this time that you're talking about. So the difficulties in getting work completed and getting things done was extremely difficult. So no, efforts have been made to have some things done, but So I wouldn't say construction hadn't started. Depends on how, that's why I was asking how you define construction. If you're talking about digging and actually equipment on
Right.
site,
Right,
that had not begun, no ma'am.
right. Now, if you look at, page 2, page 2 of, exhibit 2. It's, the first paragraph states that pursuant to the consent judgment, defendant is required to perform the following actions set forth in the plan. Complete construction and submit an engineer certification and certification for completed interconnection to the town of Harrisburg by September 9, 2022, and place the interconnection into service by May 2nd, 2022. Now, in that next paragraph 3, it states that on September 9th, 2022, an inspection of the Rocky River Plantation Public Water Supply System was performed by staff of the Public Water Supply Section. And upon inspection, the Public Water Supply Section staff member observed the following. There were no signs that construction of the interconnection to the town of Harrisburg had been constructed. And 2, moreover, there were no signs of any activity on site related to construction of the interconnection. Nor were there any signs that construction of the interconnection had even been initiated.
That's correct.
That's a correct statement.
They wouldn't have seen anything on a site visit. There was no equipment that had been dispatched or anything like that at that point in time. That's correct.
Okay.
But engineers had been hired and surveys had been conducted. Conversations with the town of Harrisburg were ongoing. Those types of things were happening. They're preliminary work before you can ever start construction.
Right, right. At any time before September, that site visit, at any time did the company reach out and say, we're not going to make our milestone?
We provided, as required, we provided updates, regular updates on progress and what was done.
Right, but I hate to interrupt you, but did you inform DEQ before September 12, 2022, that you had not begun construction and it would not be done by the September 9th?
Well, I would respectfully request that Mr. Abbott be allowed to answer the question without being interrupted.
That will be allowed, Ms. Holt. Mr. Abbott may respond. I'd also like to just clarify for the record, I think I heard a while ago, we were talking about Exhibit 2. We're actually on Exhibit 3, page 3 of 38. This line of questioning is where she's referring to. Thank you.
Thank you.
You were going to finish an answer and you were interrupted, Mr. Abbott. You want to finish, please?
Yes, please. So we provided regular updates to DEQ as to the status of construction, what activities we were performing to try to comply with the plan. And so by submitting those updates, it was easy for them to see we were woefully behind in getting things done that needed to be done. And they could easily see that there was no way the construction was going to begin or be completed by that time. They hadn't even received plans for their approval at that point in time. So clearly they knew that we weren't going to be able to meet that deadline. And again, I'll state we're in the middle of either we might have been in the pandemic at that time or just coming out of the pandemic. And I don't remember exactly when the pandemic ended, but the pandemic impacted all of this.
Let's see. Okay, I'm going. Now, did you at any time, did the company at any time contest the factual allegations contained in this motion to show cause?
No, ma'am.
Okay. Do you understand what, I know you're not an attorney, but do you understand what a motion to show cause is?
Well, as I understood it was that if I didn't comply with this, I willfully did not comply with this, then I will be at, there would be a risk of me actually going to jail.
If you did not appear and prove why you did not willfully comply, you could go to jail.
Correct.
Right, okay. So after this was filed against you for non-compliance, the company came up with another consent judgment, correct? An amended consent judgment.
Yes, ma'am.
All right. And that was entered into on November 7th, 2022, correct?
Yes, ma'am.
Okay, I'd now like to direct your attention to that amended consent judgment. Madam Hearing Examiner, we'd like for this to be marked as Public Staff Abbott, Cross-Examination Exhibit 4 for identification.
Without objection, that will be so identified.
Now, Mr. Abbott, are you familiar with this amended consent judgment?
I am.
Okay. And you signed it, correct?
Yes, ma'am.
All right. And so in light of the motion that was filed that could have held you in contempt, the company in contempt,
Yes, ma'am.
you and your attorneys on your behalf entered into this amended consent judgment.
Yes, ma'am.
And so also, contained in the allegations of this amended consent judgment, it states that, let's see, sorry. So in order to enter into this agreement, this amended consent judgment after you violated the first consent judgment. The company had to agree to make more promises, if you will, in order to comply. And also was required to submit regular filings on a weekly basis, correct?
Yes, ma'am.
Let's see, on page 12, paragraph 2A and B. Could you read, and as part of this amended consent judgment, there were certain prescribed actions or terms to which the company had to stipulate in order to order for DQ to allow an extension. If
Yeah.
you'll read paragraph 2A.
You want me to read A and B?
Yes,
Just-
A and B.
Okay. The defendant has not completed the actions described in paragraph 1 above by December 7th, 2022. A, defendant hereby stipulates that such failure is conclusive evidence of civil contempt and waives any right to contest the same by presenting evidence or legal argument. B, defendant and plaintiff both reserve the right and preserve in all respects the opportunity to present to the court evidence and arguments regarding the appropriate remedy as a consequence of the stipulated contempt.
So basically what this meant was you have one more chance to comply, and if you don't, you waive your right to contest. You would be held in contempt.
If I think the way I read things,
You waive your right to defend yourself against contempt.
if I'm found in contempt.
If you do not comply with the stipulated terms of this consent,
Right.
amended consent judgment,
But I was never found in contempt.
you waived. No, you weren't. Because you complied after this, correct?
Not by this date, no, ma'am.
Did you provide all of your weekly compliance filings?
We did, yes, ma'am.
Okay, after this order was entered.
Yes, ma'am.
Amen. Finally. I have one final exhibit. Exhibit 5. It's entitled Order Granting Public Staff's Motion Requiring Increase in Bond. And I would like to have this marked as Public Staff Abbott Cross-Examination Exhibit number 5 for identification.
Okay, without objection, that will be so marked and identified in the record.
Mr. Abbott, do you recall the public staff's motion filed against WRI for failure to have its bond increase from $35,000 to $235,000?
Yes, ma'am. Mm-hmm.
And this was filed on September 29, 2022, correct?
Yes, ma'am.
Okay. So, and it was filed in docket number W-1034, sub 8 and 10. And sub 8 was the company's last rate case
Yes, ma'am.
prior to this one. And sub 10 involved a complaint filed by Mr. Lenny DeVito,
Yes, ma'am.
a customer of Water Resources, correct? So, now just to keep things in perspective, this motion, the motion that was filed by the public staff was approximately 3.5 years after you became aware of the elevated radium levels in well one.
Yes, ma'am.
Still hadn't made repairs, correct?
Correct.
Now, if we look on page 6 of the commission's order, well, first I'll go back and you don't have to turn to this, but on page 2, there's a summary of the pleadings. The commission counts the public staff's motion. Then on page 3, it discusses WRI's response to the public staff's motion. The public staff replied, which is summarized on page 4. And it discusses water resources report. Now on page 6, paragraph 2, beginning paragraph 2, the commission in its discussion and conclusion regarding the public staff's motion states, the first sentence states, and I'll read it. Primary among the evidence is the continued failure of WRI to comply with DEQ regulations requiring a second water supply for Rocky Rivers. And the commission goes on to list the requirements of the consent judgment and a true and accurate copy of which was attached to a motion filed by WRI. And it just goes through the list of proceedings and actions or inactions of WRI. And notwithstanding the company's excuses for its non-compliance, the commission ultimately agreed with the public staff, correct, and granted its motion to increase the bond.
Yes, ma'am.
Now, in the recitation of the facts in the commission's orders, do you contend that there were any misstatements of the fact?
I'd have to go back and read the entire order. I didn't read the order when it was issued. I just knew I needed to comply.
Okay. Well, do you doubt the commission
No.
made any error?
Never.
Okay. Good idea. In light of the list of facts regarding, it appears to be a pattern of WRI, does it not, of non-compliance? Whether you have an excuse or not.
But I would agree with that, but I do take exception to excuses. They're not excuses. They're actually facts, other facts involved, not excuses, but facts involved as to why there was ongoing delays.
And I might add that even today, we received another example of the company's failure to comply on time with its failure to file the supplemental customer report, correct?
Today was the first I heard of that, so It was an oversight on my part, that's all I can say. I don't recall receiving anything.
Mr. Abbott, if WRI had complied with all of the timelines and met its deadlines prior to June 17, 2021, would the DOJ have needed to file a complaint or motion for injunctive relief?
Yeah, if we had not had a pandemic that shut down the entire economy of this country, that prevented any work from getting done and any progress being made, yes, I would say we would have met that deadline.
But would you also say that they wouldn't have needed to file these motions had you, notwithstanding whatever, I won't say excuses, reasons you state, had you complied, timely complied with the milestones, would they have needed to file a complaint for injunctive relief?
No, but I also think that the courts found that the reasons were justified. That's why I was never found in willful contempt of court, as we explained the delays and what was causing the delays that were outside of our control. This wasn't a matter of efforts not being made. You're correct. It wasn't a lack of effort between the pandemic and the after effects of pandemic with a shortage of supplies and labor and those types of things. All of those delays caused that, but you're absolutely correct. If we would have completed by the 21st, then it wouldn't have been necessary for that to be filed.
Now, the court didn't actually rule on the motion regarding finding you. The court did not say you're not in contempt, did it?
It was dismissed. The case was dismissed, I think is the way it reads. I'm not an attorney. I know the court found that we did what we needed to do and never found that we were on willful contempt of court and willful breach of our agreement. And so they never found me in contempt of court. That's all I know. And then when we finished the project, the case was dismissed. I don't know the legal aspects. It's called dismissed or you're not found guilty or whatever the case was. I don't think that I was ever charged with contempt for them to actually move forward with a hearing or a trial to see if I was in contempt. I think the whole matter, again, I'm not an attorney, so I don't know this, but I think what the hearings before the judge was about was to decide if contempt charges should be brought against me in the company.
But
that never proceeded to that level.
But isn't it true that if you had not met the terms of the amended consent judgment, you would be held in contempt?
I could have been. Mm-hmm.
Thank you. No further questions.
Yes. Thank you.
That last answer, Mr. Abbott, I think as you said 2 or 3 times, in order for you to be found in contempt, you would have to be a willful violation. Is that not right?
That is correct.
And you did have to go to court, did you not?
That's correct.
A number of times.
I did.
And did the Attorney General's office ever ask the court to find you in contempt, willful contempt, for failure to meet the deadlines established in these various documents, the consent judgments?
They did not.
Never asked for that, did they?
No, sir.
And you had to go and you had to explain first to the Attorney General's office, then to DEQ, the difficulties you were having in meeting the deadlines that had been imposed on you. Is that correct?
That's correct.
And after you explained it to them, they kept pushing. But you were doing the best you could and they couldn't push but so hard, isn't that correct?
That's correct. They understood this was all a result of pandemic and trying to get things done during the pandemic and after the pandemic and what we were dealing with from an economic perspective.
Has anybody said, Mr. Abbott, that you should have had the interconnection with the town of Harrisburg in accordance with these? Did ever tell the court that you should have had these interconnection in place by the time these deadlines were established?
Did I tell the courts that?
Did the Attorney General's office ever say that you should be held in contempt for willfully complying with the deadlines?
No,
And you haven't been held in contempt?
that's correct.
And mentioned the fine of $4,500. What happened to that?
The Attorney General's office and DEQ decided that they would waive that fine and there would be no further penalties for the action, for the delays.
And the responses that you made to DEQ and various reports and that you made to the court were what you were doing to say why you shouldn't have to pay those fines and why you shouldn't be held in contempt.
That's correct.
And you were successful in the end.
That's correct.
All right, now this bond here, you had some lawyers helping you both in addressing the need for this bond and ultimately in filing the increased bond, did you not?
Yes, sir.
So in the end, you were complying with a commission order motivated by the public staff, and you had some lawyers to help you do that. Is that not correct?
Yes, sir. That's correct.
Have you ever tried to file something in the clerk's office, Mr. Abbott?
I'm not sure I understand what you're asking.
Well, but if you had tried, you would understand.
I just know that I'm always told you need to have an attorney do this. You need to have an attorney do this.
And you had to have attorneys when you went to court.
That's correct.
And you had to go to court and explain to the court what you were doing and the reasons why you were unable to meet the milestones. Yes.
That's correct.
Is there any way possible, Mr. Abbott, that you could have met these milestones in light of the obstacles that you confronted?
No, sir.
And you explained that.
That's correct. Nobody has a crystal ball whenever we set these timelines and deadlines we're trying to meet. It's our best estimate, and things happen that are outside of your control that moves to that deadline. And we would have known we were going to have a once in a lifetime pandemic.
No further questions.
Mr. Abbott, can I ask you about, on page 9 of your direct testimony, you talk about getting the easement, finally being able to get the easement that was needed for the connection to the town of Harrisburg in exchange for a payment. Can you tell me a little bit about the process of getting that easement and how long that took and what was the problem there?
The homeowner there took us some time to get a response from her. And once she finally responded, it was very short and to the point, says, "I'm not interested. Check with my neighbor across the street to see if they'll give you an easement." So we continued trying to secure the easement, contacting her. And then, of course, the pandemic came along as well. Finally, after months and months and months of trying to talk with her, going through an attorney to contact her as well, we finally had to tell her that if she wasn't willing to give us an easement voluntarily, that we would have to begin condemnation through the courts, which we didn't want to do. It was going to be costly for us and certainly costly for her. It's not the way we like to do business either. Once we stated that, she came back and said she would, but she put a lot of conditions on it and a handsome price, quite frankly. But at that point, because we were so far behind, we wanted to move forward. So I paid her everything she asked for to get the easement, which was a little under $9,000, I believe, for just a very narrow easement. And other conditions, regarding construction and returning the property to the condition we found it.
And how different was that from your original offer or what you were hoping you would pay for that easement? How much more was the 9,000?
Well, in talking with my attorneys and their past experience, they felt like something around 4,000 or 4,500 was appropriate. So it was about double what we thought would be appropriate.
Mhm. And is that a perpetual easement? I mean,
Yes, ma'am.
okay, all right. And did you ever contact the neighbor, or was that just not an option, really?
It really wasn't an option from talking with my engineers.
All right. And
Because, so the reason why is because our water main was stubbed out to the road on her side of the road. To go to her neighbors would have meant we would have had to take the water main and cross the road in the neighborhood and then do a tie-in. So that wasn't really feasible. It would, I guess in reality it was, but it would have been cost us a lot more money to construct it that way.
And I think I heard when you were first responding to Ms. Holt with the first exhibit, which was the complaint and motion for injunctive relief. You knew you had the easement problem to work out, but you also said you had to make that connection with Harrisburg. Now, did you run into problems with Harrisburg, or were they receptive to this from the beginning?
We ran into problems just getting them to respond to us. And took us a while to find the right person within the town of Harrisburg. We contacted their director of, I guess, public utilities. So I'm not sure the exact title, but the person that oversaw that for them didn't get a response. Ultimately, I think I finally got a response from the town manager, who redirected me to the proper person. And then that took some time to get a response. So it was months just to get them to respond. And I was following up every 10 days, 2 weeks with them to try to get them engaged. Once we got them engaged, I would say their response was slow, but they did respond. And all the requests, they were somewhat slow. And typically would require sometimes 2 and 3 follow-ups with them.
And was that you directly, did you say, or your attorneys?
No, it was either myself or Beth Lockwood in our office. The two of us were sort of both following up with them.
And one more question. When Mr. Finley was asking you, about your conversations with, DEQ about the status, you were given these status reports, and they started out quarterly and they turned to weekly reports as time went on. He made the comment that the pressure was on. I mean, were you feeling that when you gave these weekly reports?
Yes, ma'am. I didn't want to go to jail.
So were they verbal reports or written reports?
Written reports.
Okay,
Yes, ma'am.
okay. And would they respond back to these written reports?
Sometimes they would call, they may email, and they would ask for clarification, but they never challenged anything that we were doing, as we weren't making the proper effort to move forward, and we weren't doing the right things to try to get the project to completion.
Okay, all right, thank you.
Yes, ma'am.
Any questions on commission questions from public staff?
And, Mr. Abbott, when did you first begin, negotiations on the easement?
I'd have to go back in my notes and look and see. There's a lot of dates and a lot of milestones. I can't remember exactly when I started negotiations with her. There was a period of time, because I didn't even know I needed an easement. Originally, there's 2 entrances to the community. And originally we wanted to use the other entrance. And I engaged an engineer and a survey company to study that. And by the time they finished and came back, they said it wasn't possible. And so we had to start over at the second easement, the second entrance, which is where Ms. Hook's property is. And had the survey and the easement drawn up and, basically preliminary engineering done of where everything would have to be. So I can't remember the exact date, to be honest with you. It wasn't immediately after we took the well offline because there was, again, engineering and surveying going on and those types of things.
Okay, not immediately, but was it
It was timely once we knew that we needed an easement there, wasn't it?
within a year? 2019?
I would think so. Without checking my notes, I can't confirm that, but I would think so.
Okay. And when did the easement situation, when was it resolved? When did you reach agreement?
I'm sorry, I don't recall the exact date of when that was resolved.
Mr. Finley, did you have?
Yes, a few
questions?
questions, please. So the lady's name, the property owner is Ms. Hooks,
Correct.
and she had representation, did she not?
She did.
And she came with you with some terms in the easement that she suggested she might sign with you, and you couldn't live with those, is that correct?
Correct.
And she was a person who changed her mind from time to time.
I would say that would be a correct.
And I think at one point she insisted that the document be executed in the Superior Court, is that right?
That's correct.
Yeah. All right. And about the negotiations and so forth and oversight with the town of Harrisburg, what was it correct that at one point you thought that Harrisburg was okay with you following the plans and specifications of Charlotte Utility Mecklenburg District, and when you went back to the town, they said, nope, we want you to comply with the town of Harrisburg directives?
Correct. Before we ever submitted the actual plans to the state for their approval, we submitted them to the town of Harrisburg. And they approved the plans. We then submitted them to the state, which they approved, so we thought we were ready to go. And then the town of Harrisburg came back and said, oh, no, we need to change this. And that caused an additional delay because the changes they wanted meant we had to order custom materials. They weren't just regular run-of-the-mill materials that you would order.
Did that add time to have to get the custom materials?
Absolutely. It added at least 2 more months just for that one piece.
And you had to have approvals or permissions from Department of Transportation, the town of Harrisburg, DEQ?
That's correct. All 3 of those. We were doing a boring underneath a state maintained road. So we had to get the Department of Transportation approval. We also had to get inspections, not only for approvals, but by all 3 of those agencies as well. So there was a lot of governmental agencies involved in approvals and coordination with them as well.
Approval from Ms. Hooks.
Yes.
And am I correct in my understanding that from time to time you would have meetings scheduled on site there? And some of these people who were supposed to give the approvals for whatever reason didn't show up?
That's correct.
And you explained all this to DEQ and to the Superior Court?
Yes, sir.
Did you explain it to the public staff and make reports to the Utilities Commission?
We had conversations with folks on the public staff, and making them aware of delays and what the status was and the progress. I don't recall if we gave written reports, but we did. And I know that public staff and DEQ were in conversation as well about what was happening.
Mr. Abbott, were you taking this lightly and just letting the time go by without addressing these issues?
No, sir. I'm not a procrastinator, and I wanted to get this done as quickly as I possibly could. Because at one time in 2021, we did give notice that we were going to apply for a rate increase. I desperately needed a rate increase. But we ultimately did not move forward with the application because we didn't have this interconnection done. I wanted to get this interconnection done so I could recover the cost. Also in this rate case, I was losing money operationally. I needed to get all of that corrected. So it was to my benefit to get this done as quickly as possible so I could get rate relief to recover the money I spent to do this.
So you understood that to get rate relief for this $470,000 improvement, you had to have it complete.
Yes, sir.
And did that give you any incentive to get it completed as quickly as you could?
Gave me a lot of incentive. Yes, sir.
No further questions?
All right, thank you. Mr. Abbott, you're excused for right now. You'll be back on rebuttal.
Okay, thank you.
Okay. Mr. Finley, is that your direct?
That's the right case. Yes, ma'am.
Would you like at this time to admit your application into the
That would be fine.
record?
We would move admission of the application.
And the amended application that
and-
was filed on January 3rd?
So move.
And the amendment to the effective date letter on January 22nd as well.
So move.
All right, so without objection, those three filings related to the application will be admitted into the record. And with that, as we're switching witnesses here, we're going to go ahead and take our afternoon break here. I take a 10-minute break for the court reporter, and we'll come back with the public staff's case. Excuse me.
I'd like to
Oh.
move the admission of.
Excuse me, yes, please.
I think they've been admitted, but no objection.
Okay. You go ahead though, Ms. Holt.
I'd like to move the admission of public staff, Abbott cross-examination exhibits 1, 2, 3, 4, and 5.
Yes, and they
Thank
will
you.
be so admitted as identified and pre-marked. So thank you. All right, so with that, we're going to take a 10-minute break. We'll be back here at 2:30, 2:40. 2:40, okay, do math up here. Thank you. Back on the record. Ms. Holt, would you like to call your first witness?
Yes, the public staff calls Evan Hauser.
And Ms. Holt, as he's coming up, can I ask you and Mr. Finley, would you like or have any objection to us copying the summaries into the record as if given orally from the stand versus them reading them orally this afternoon?
That would be fine.
No objection.
No objection? Okay, then we'll do that starting now. Mr. Hauser, if I could swear you in before you get started, I'm gonna ask you to put your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you.
Mr. Hauser, on April 2024, did you pre-file testimony consisting of 40 pages in question and answer format? An
Yes.
appendix
Oh,
and
sorry.
2 exhibits?
Yes.
Do
Yes,
you have any changes or corrections to that pre-filed direct testimony?
I do. I have two quick changes. The first one is on page 28, line 19, and I'll just let everybody flip to it. Looks like we're all there. Okay, so on line 19, it currently reads as filed on the 12th, repairs from 2022 test year costs, and there's a comma. The 3 words preceding the comma should be replaced with the words plant in service. So the line should read repairs from 2022 plant in service, comma.
Any additional?
Yes, the second revision, I suppose, or correction is on page 39, line 7. I'll give you all another couple seconds to jump to that. So the number on that line, which reads as filed 373%, should be corrected to 384%.
Is that it?
Yeah, that concludes the corrections.
If I were to ask you the same questions today, with those corrections, would your answers be the same?
Yes.
At this time, Madam Hearing Examiner, I move that Mr. Hauser's direct testimony as corrected be copied into the record as if given orally from the stand, and that the appendix and exhibits attached to his direct testimony be identified as marked when filed.
Without objection, that will be allowed.
Mr. Hauser, on April 26, 2024, did you file supplemental direct testimony consisting of 3 pages and 1 revised Hauser Exhibit 2?
Yes,
Do you have any changes or corrections to your supplemental testimony?
I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes.
I move that Mr. Hauser's supplemental direct testimony be copied into the record as if given orally from the stand, and that the exhibit attached to his supplemental testimony be identified as marked when filed.
Without objection, that will be so allowed.
And Mr. Hauser, do you have a summary of your testimony?
Yes,
Oh.
I said,
In lieu of reading that, the public staff will provide that to the court reporter
Ye-
and file it. Does that meet your approval?
Yes,
And entered into the record.
and entered into the,
We'd like,
excuse me.
respect, we'd like to see it first.
Do you have a copy?
I have 5. Yeah.
Thank you.
Thank you. This is two, okay. And is this the,
No
Direct
objection,
or-
no objection.
Excuse me.
Copy that into the record.
okay, thank you. And this is the direct and the supplemental? Yes, okay.
Yes, that's correct.
All right, so without objection, this will be copied into the record as if given orally from the stand.
And, with, the commission's approval, I'd like to conduct additional limited to direct, regarding the report that the commission required that we filed. This supplemental customer report.
Okay, yes, that was required by the commission order. Yes, please proceed.
Mr. Hauser, can you briefly summarize the commission's May 6th order?
On May 6th, the commission ordered the company to file a supplemental verified report addressing the HOA statement, which is filed as Stremovich Exhibit 2 on or before Thursday, May 9th, and ordered me to either respond on Friday, May 10th, or address it today on the stand.
Okay, could you briefly summarize the HOA statement?
The HOA statement outlines customer concerns with the proposed increase, customer service quality, water quality, billing, and customer recommendations regarding the rate increase. My testimony outlines my recommendation to address a number of issues raised in the HOA statement, including customer communications, deadline for implementation of the website, and investigating the filter and tank for causes of water discoloration.
Please provide your verbal response as required by the commission order.
As of today, the company has not filed a report addressing the HOA statement. Furthermore, the public staff acknowledges the magnitude of the proposed rate increases, especially for Rocky River customers, and the impact that can have on a household budget. The adjustments recommended by the public staff are reasonable, adhere to rate-making standards, and mitigate the rate impact to some degree.
The company has indicated that they will file a report as a late filed exhibit. How much time would you need to respond to that report?
I'd like to request that the commission allow 2 business days following the filing date of the company's report to allow me to examine the company's report in comparison with the HOA statement filed as Stremovich Exhibit 2.
That request will be allowed.
Mr. Hauser is available for cross-examination.
Thank you. Mr.
Now-
Finley, thank you.
Mr. Howells, if you would turn to page 30 of your testimony, please. And beginning on page 11, line 11, you removed all legal fees related to preparing for hearing, consultation with WRI and other parties, and representing WRI in contempt and other proceedings related to WRI's failure to comply with the consent judgment entered into between WRI and the DEQ on July 15, 2021, and half of the legal invoices related to the consent judgment and amended consent judgment dated November 8, 2022, issued by the court. Legal fees related to the consent judgment are incurred due to the prolonged period of noncompliance with well number 1, when well number 1 was taken offline for an extended period and should not be borne solely by WRI's customers. That's basically what you said, is it not?
Similar.
Pretty close. You do understand that the purpose of the preparation for and appearing before the Cabarrus County Superior Court was to report to the court with DEQ and the North Carolina Attorney General's Office on the progress made by WRI, among other things, the construction of the interconnection with the town of Harrisburg.
And those legal fees would not have been required to be incurred if the company had completed the project to any of the numerous deadlines set forth by NCDEQ.
But your answer to the question is yes?
because the project was not completed to a timely manner with NCDEQ's requirements, yes, they brought a complaint forward requiring the company to be in court.
WRI and DEQ negotiated mileposts for steps for completing the interconnection or otherwise eliminating the situation where well number one was offline, right?
Sorry, repeat that.
DEQ and WRI negotiated mileposts or steps for completing the interconnection or otherwise eliminating the situation of well number one being offline, correct?
As part of the consent judgment?
Yes.
Or, my understanding is that as part of the consent judgment following the complaint brought forward in 2021, that, let me jump to it. That there were certain terms the parties, specifically WRI, was required to follow following a consent judgment.
Well, it was a consent judgment, CONSENT judgment, wasn't it?
Consent, CONSENT.
Consent judgment.
Did I say something differently? I'm sorry.
It was a consent judgment, was it not?
Yes, it was a consent judgment.
All right, I want you to, you have read the rebuttal testimony, have you not?
Yes.
All right, I want to read you a sentence in the rebuttal testimony from page 9, line 13. Have you respond
Give me
to
1
it,
second.
please?
You said page 9, line 13, is that
Yes.
correct?
Ms. Holt asked Mr. Abbott some questions about these documents. So you were here in the hearing room when that took place, were you not?
I was.
All right. Here's the statement I want to read to you. The November 8, 2022 amended consent judgment, paragraph 16 states in its description of the July 16, 2021 consent judgment, the parties initially reached a resolution of the injunctive relief sought by plaintiff through this suit and memorialized the agreement in the consent judgment, which was entered into by the court on July 16, 2021. As cited in paragraph 23 of the November 2022 amended consent judgment, the parties seek to memorialize the actions the defendant will take in the future in this amended consent judgment. So that it was an agreement that the parties reached.
Yes, the parties reached an agreement after the complaint was brought forward by DEQ, but I'd argue that this agreement was not necessary if Water Resources had completed their project to the timeline set up by NCDEQ.
Did you argue anywhere in your testimony, Mr. Hauser, that the company could have complied with those deadlines? Do you argue that any place in your testimony? If you do, just show me where it is.
It's not written in my testimony.
To the extent the parties had disagreements leading up to these consent judgments, it was a compromise, wasn't it? To your knowledge.
Presumably the parties jointly agreed and signed.
You do not address any knowledge you have of the negotiations leading up to the terms of the consent judgment in your testimony, do you?
My testimony outlines the actions which led up to the consent judgment.
Do you address any negotiations that the parties entered into, the DEQ and the Attorney General's office and WRI leading up to the terms of the consent decrees?
You're asking if I detailed the negotiation between the
That's
parties
what I'm
in
asking
my
you.
testimony. No, I did not detail negotiation between DEQ and Water Resources, Inc. in regards to the consent judgment.
And you do not dispute that the purpose of the work and the representation was to show the environmental regulator and the court, which oversaw the consent judgment, what WRI was doing, among other things.
Sorry, your question was that I do not dispute that the purpose of the consent judgment was for,
You don't dispute that the purpose of the work and the representation was to show the environmental regulator and the court, which oversaw the consent judgment, how WRI was doing.
the need for the work was only created by the project not being completed in a timely and prudent manner.
Well, we'll accept that for every answer you give if you want to, but would you please answer the question?
Please repeat the question.
You do not dispute that the purpose of the work and the representation was to show the environmental regulator and the court, which oversaw the consent judgment, how WRI was doing.
The purpose of the work was to appear to represent the company for the complaint. Yes, generally.
So that's a yes generally?
No, I do not dispute your statement.
And you do not dispute that and I'm talking about what you say in your testimony here. You do not dispute that WRI was successful in explaining to DEQ, the Attorney General's office, and the Superior Court that the actions that were taken to complete the interconnection with the town of Harrisburg were ultimately appropriate.
Sorry, you're gonna have to repeat it one more time.
All right. You do not dispute that WRI was successful in explaining to DEQ, the Attorney General's office, and the Superior Court judge or judges that the actions it was taking to complete the interconnection with the town of Harrisburg were appropriate.
I did not dispute it in my testimony.
Now, the public staff did not participate in the proceedings before the Superior Court, did it?
Not that I'm aware of.
Well, Mr. Abbott has been asked a lot about the consent judgment. You do understand how that all came about, don't you?
My understanding is that the company received 3 MCL violations beginning in the fall of 2018, leading into the early part of 2019. Following the MCL violations, the company took its well offline and in violation of NCAC 18C 0402G5.
So the answer to the question is yes? You don't know what the question was, do you?
Yes, I generally understand the actions that led to it.
Did you review any of the transcripts before the court?
I did not review the transcript.
Did you listen to it online?
No.
You do not state in your testimony that you interviewed DEQ, Ms. Menard of the Attorney General's office to learn more about what transpired, do you? You do not indicate that you know the names of the judges before WRI appeared, do you, in your testimony? And you don't know, and you don't list in your testimony whether the appearances before the court were virtual or in person, do you?
No.
And you do not indicate in your testimony whether you understand that WRI confronted obstacles in completing the interconnection as quickly as DEQ wished and in compliance with mileposts initially established, correct?
All projects run into issues. It's typical for projects to run into issues.
Well, I'm asking, Mr. House, I'm asking you what your testimony says.
No, that is not discussed in my testimony.
Yes. And you do not indicate in your testimony that you understand that the state, while pushing WRI, never concluded that what WRI was doing to remove the obstacles constituted a willful refusal to comply with the consent judgment or judgments, correct?
All right, can you reiterate the very first part of that question?
You do not indicate that you understand that the state, while pushing WRI, never concluded that what WRI was doing to remove the obstacles constituted a willful refusal to comply with the consent judgment.
That's, again, yes, that's not in my testimony, but
Repeat it again, go ahead.
that is not written in my testimony.
No. Now, you also do not acknowledge that the purpose of the hearing before the court was not to hold WRI in contempt, but to monitor the progress made to complete the interconnection. You don't acknowledge that, do you?
Not in my testimony.
Now, you've conducted some discovery of the case, and you looked at the bills for legal services, correct?
Yes, I removed them or reviewed them with public staff legal.
And from time to time, there would be a reference to contempt in some of those bills on the itemized numbers.
Yes, that's
Yeah.
correct.
But you do understand that that is a sort of a shorthand version in the bills to explain the more detailed action that was taken before the court.
I'm
Right.
gonna object to this line of questioning. As Mr. Hauser stated in his testimony, he opined on the legal invoices based on his consultation with his counsel. We can include this in a brief in our proposed order.
Mr. Finley, would you like to respond?
I certainly do. The public staff has a habit of putting up an engineer to make these points upon which it asks the commission to make these substantial adjustments. And when you ask them about it, they say, oh, I consulted with, we don't have counsel to cross-examine. If that's the way they want to do it, then all that stuff ought to be stricken. If they're relying upon hearsay witness from a lawyer who's not here, that's a cop-out, and it shouldn't be allowed. And I'm entitled to ask what the witness is testifying to and why he supports it.
Okay, I'm going to allow the line of questioning for now, and please proceed, Mr. Finley.
Thank you. And Mr. Hauser, you do not address the ultimate penalty and this contempt issue would have been to fine the company, perhaps put Mr. Abbott in prison. You don't address that in your testimony, do you?
You're referring to the fine by DEQ?
I'm referring to what you said in your, I'm asking you about the testimony and the support for the recommendation you make and what you said in your testimony.
The reason for the company ending up in these legal proceedings was because it did not complete the project to DEQ's required timeframe. For the company was arguably aware in 2018 of their increasing levels of radium in well 1. And that led the company to take well 1 offline in knowing violation of the North Carolina supply standards. And if the company had acted prudently in a timely manner to address the interconnect quickly or at a reasonable pace as set out by DEQ, and DEQ gave them multiple extensions, they would not have incurred any of these legal fees. Potentially, they would have incurred none. So,
Mr. Hauser, are you finished with your answer? I don't want to interrupt you. You finished with your answer? You've given about the same thing about 6 times now. You finished? Where in your testimony do you say that the company was imprudent in what it did to interconnect with the town of Harrisburg? Where is it? Show me in your testimony where you say that.
it's not written directly in my testimony.
No, it's not. And you're not making a request, are you, that any of that $470,000 be disallowed in this case, are you?
I think the costs incurred for the actual construction of the project are reasonable. And we're recommending removal of some costs related to legal fees because we believe the legal fees were imprudently incurred.
Well, you don't say anything in your testimony if those fees were illegally or imprudently incurred. If you did, show me where it is.
Not all, I don't believe all of the reasoning for all adjustments made in this proceeding need to be explicitly laid out in the
Oh,
testimony.
you don't? Did your counsel tell you that?
No.
I'm gonna object again. What he discussed with counsel is confidential. And I'm gonna leave it at that.
Well, then I move to strike everything he said where he says that it's based on advice of counsel. If it's confidential and I can't question him about it, then it has no business in this
You
case.
asked him what he discussed with counsel, what counsel said,
Yes, ma'am.
and that is not,
I'm going to
that's inappropriate.
I'm going to interrupt here, and what we'll say is, we're going to sustain that the witness does not speak about matters that are informal discussions with this council. However, what's been put in this testimony, which is public record, Mr. Finley, you may cross-examine on that, and the witness will answer to the best of his knowledge. Thank you.
Well, in all due respect, Madam Hearing Examiner, I'm going to reserve the opportunity to move to strike testimony of the witnesses, pre-filed testimony where he says he relied upon advice of counsel.
So
I said
noted.
another time.
So noted.
And you do not testify in your testimony, do you, Mr. Hauser, that WRI willfully failed to comply with the milepost established by DEQ to complete the interconnection with the town of Harrisburg? Willfully, you don't say that, do you?
No.
And you do not testify that after the process was complete, the initial fine of $4,500 has been rescinded. There will be no more fines and there's no contempt. You don't say that in your testimony, do you?
And the fine, the administrative penalty used by DEQ is a tool to move the system towards acting in compliance with their standards. It's not explicitly written in my testimony.
And you do not testify, and you do not mention in your testimony that WRI was successful in avoiding fines ultimately and the penalties and avoiding contempt. You don't say that in your testimony, do you?
That is not written in my testimony.
And you do not testify that DEQ was dissatisfied with the interconnection with the town of Harrisburg and has ceased to require ongoing reports to the court to address issues in the consent decrees, do you?
I did not explicitly discuss that in my testimony.
And you do not address Ms. Hook and the role that she played in WRI's ability to interconnect with the town of Harrisburg. In your testimony, you don't discuss that, do you?
That's not discussed in my testimony.
And in your testimony, Mr. Hauser, you do not indicate that you were aware of the delays encountered by WRI in completing the project as a result of COVID interference, do you?
I'm going to object to this line of questioning. You're asking the witness what's not in his testimony as opposed to what is in his testimony.
Oh, yeah, that's completely right. And I'm leading up to what I believe to be the legal standard in this case. And I'm going to be sure I'm not going nowhere with it, Ms. Holt.
Okay, for now, we're going to allow this, Mr. Finley, we're going to allow this line of questioning
Thank
for
you.
now to
Thank
get
you.
to your point.
Thank you. And you do not indicate in your testimony that you are aware of the delays experienced by WRI in obtaining permission from DOT to use the right-of-way and access to the roadways to complete the interconnection, do you?
I do not.
And you do not indicate that you are aware of the differences of opinion between the town of Harrisburg and CMUD over the specifications of the vault and valving requiring interconnection, do you?
No.
And you do not testify that you're aware of delays caused by meetings that were held on the site and some of the parties failed to, who had to give attention, failed to appear, do you?
No.
And you do not testify that you are aware that the vault into which the valve was installed had to be cast specifically for this particular project, correct? Now, after WRI submitted its rebuttal testimony taking issue with most of your adjustments, the public staff filed a comprehensive data request that you maintain was due 24 hours asking for voluminous information about the actions WRI took to replace well number 1 with the town of Harrisburg interconnection, didn't you?
My understanding is that the company had agreed to respond to that data request in 1 day prior to the public staff providing that data request to the company.
Well, they didn't agree to that particular data request before, haven't even seen it, did they?
I don't think you typically agree to what's in the data request prior to receiving it.
No. But let me read you what you had in question number 1 of the data request after the rebuttal testimony. Did you have any role in preparing the data request?
I'm aware of what the data request is.
Question number 1, on page 5 of the company's rebuttal, the joint witnesses state that the public staff makes no allegations that WRI should have taken actions that would have resulted in activating the interconnection with the town of Harrisburg, Susan, that it did. Please provide a list of actions performed by WRI staff in 2019 and 2020 to resolve radium contamination well number 1, and following the well's removal from service, actions taken to provide an additional source to comply with 15A NCAC 18C.0402G5, period. Please provide actions taken by WRI staff, the name of the staff member who took the action and the date of the action taken. Please also provide supporting documentation for each action. I basically read that correctly, haven't I?
To my understanding, subject to check, that's.
Was the public staff unaware of the answers to these questions when you made your recommendation with respect to the disallowance of the legal fees in your direct testimony, and waited until the company had filed a rebuttal testimony to inquire into the steps the company took with respect to well number 1?
The company didn't incur any costs related to this project until August of 2021. So I think it was subject to investigation what actions the company had taken prior to the occurrence of costs related to the interconnection project.
Yeah, well, okay, but my question is, why did you wait till the rebuttal testimony? Did you not make that investigation before you complied with your report and submitted your testimony?
Based on the documents that are available in the amended consent judgment and the consent judgment, it seems like there are significant gaps of time with questionable amounts of progress towards the interconnect. So I think it's a reasonable question to ask.
Yeah, but my question to you is not the reasonableness of the question, but the timing of the question. Why did you wait until the rebuttal testimony was filed and not before you came up with your recommendations?
Don't have an answer as to the.
I'm sorry.
Said I did not have an answer as far as the timing of when we asked.
And of course, one of the things the company had to do in response to that data request, where you wanted an answer in 24 hours, was to say they had to rely upon looking at the order that the commission issued about discovery request, and said, oh, by the way, you have violated the order about what you're supposed to ask on discovery rebuttal, right? You remember that?
Sorry, you said the company,
Objected to that question.
I'm aware the company objected to the question.
Right. And one of the things the company, the public staff wants to do is limit legal fees, correct? You know, in order to do battle with the public staff, the company's got to have its own lawyers and to address the questions that you ask and that type of thing. You'll agree with that, wouldn't you?
Sorry, are you asking if the public staff is attempting to limit legal fees related to the consent judgment? Because that's covered in my testimony. The professional expenses covered in the testimony of witness Feasel.
Okay. How many data requests did the public staff submit to the company in this case?
12.
Now, the provision, how aware are you, Mr. Hauser, about these consent judgments? I mean, the Attorney General's office and DEQ enters into these things with some regularity. Are you familiar with that?
Sorry, excuse me. Sorry, you asked how familiar I am with the consent judgment. You meant a consent judgment was filing. Is that correct?
Yes.
Yes, I'm familiar with the documents.
And don't they always include in their consent judgments this provision about if you don't comply, you may be subject to contempt? Isn't that a standard provision in the consent judgment?
If you know the answer to that, he is not an attorney.
If the witness will respond to the extent he knows.
I'm not aware if it's something that is always included in these.
Have you seen it in other consent judgments?
I haven't specifically reviewed these documents for that language.
Have you ever reviewed other consent judgments that deal with companies besides water resources?
I have not specifically reviewed other consent judgment documents for this proceeding.
And nowhere in your testimony do you maintain, Mr. Hauser, that with respect to the work undertaken to report to DEQ and to appear in the Cabarrus County Superior Court, the steps which WRI took were imprudent or were unreasonable. You don't put that in your testimony, do you?
It's not in my testimony, but that doesn't mean that that may not be the fact of the case.
Do you argue that WRI, in your testimony, do you argue that WRI should have insisted on fewer reports to DEQ or fewer appearances in the Cabarrus County Superior Court? And you do not maintain, do you, that the preparation undertaken was, in your view, wasteful or excessive?
And as our treatment of legal expenses recommended in my testimony, we recommend the removal of half the legal expenses related to the interconnection. There's some legal costs which we understand were incurred due to Water Resources' need to report to the Attorney General, the Department of Justice, the Utilities Commission, and I suppose copy our public staff and DEQ. So we're not recommending removal of all costs related to legal fees because we understand that there are some costs which are related to reporting, which became necessary.
But nowhere in your testimony do you show what formula you came up with to divide the cost to be recovered from customers and the costs that were not to be recovered from customers. You don't say how you came up with that calculation, do you?
I don't think you can calculate it because the amount of legal fees that would have been incurred is unknowable had the company acted quickly or in a prudent and timely manner to place the interconnection in service, or if there even would have been a complaint brought forward by NCDEQ. Because it seems like in the consent judgment, it outlines that DEQ was willing to provide Water Resources with an extension, given that they showed there had been delays in acquiring their easement up until 2020, between September 2019 and September 2020. There was extension given, so it's plausible that if the company had been able to show DEQ that they had been incurring delays, that DEQ may have given them an additional extension and the complaint never would have been brought forward.
On page 30, line 17, you say legal fees related to the consent judgment were incurred due to a prolonged period of noncompliance when well number 1 was taken offline for an extended period and should not be borne solely by WRI's customers, correct?
What line did that start on?
Page 30, line 17.
I mean, I'll accept that what you read is similar to what my testimony says.
And it's what the phrase I want to ask you about is, and should not solely be borne by WRI's customers. You do say that.
Yes.
And that's your justification for disallowing these legal fees because your view is that it's unfair. It's unfair for the customers to bear some of these costs. Isn't that right?
In this case, the application by the company requests that the customers bear all of the costs.
Yes.
So I think it would be, I think it's unfair for the customers to bear all the costs. And I think that the company is trying to convince the commission that even though the company has a continued habit of delaying taking action until they're on the cusp of serious legal issues, that in this one case, they acted prudent and reasonable and incurred, at the time, happened to incur significant volumes of legal costs.
Nowhere in your testimony, Mr. Hauser, is the word reasonable and prudent anywhere, is it? You're basing it on unfairness, not reasonableness and prudence, do you? Show me if you use reasonableness and prudence in your testimony. I'd like to see it.
I'm not immediately aware whether or not that's in my testimony.
You're not aware? It's your testimony. It's not in there, is it?
It's 40 pages of writing. I mean, I'm not sure if
You need some time to look to see if reasonableness and prudence is in your testimony. And so this business of unfairness is your opinion. Right?
Is that a question?
Yes,
I don't,
reasonableness and fairness is your opinion, right?
I don't believe the customers should be required to bear the costs associated with non-compliance with DEQ's regulations.
You don't believe it, but in other words, that's your opinion. Now, again, you do not testify that that is the opinion of your consultants with the legal arm of the public staff, do you?
You asked if I testified that that was the opinion of this recommendation is made in concert with working with the public staff and legal division.
Well, I don't see where you say that in this page 30 on line 17. Is it your opinion or somebody else's opinion?
It's my opinion.
Did you ask your legal consultants on the public staff what standard the commission uses to determine whether or not legal costs incurred, are to be recovered from rates or not? Did you ask them that?
Did I ask the public staff legal division?
That's my question.
Object, that's attorney-client privilege.
I was sustained that, yes, let's do not pose our questions regarding, the witness's discussion with his legal counsel. This, let's stick to what's in the testimony.
Madam Examiner, I have to ask you for making an offer of proof.
All right?
So the question, this is the court reporter, would you please indicate that this is making of an offer of proof? My question to you is, Mr. Hauser, when you were getting your advice from legal counsel, did you ask them what the standard was under which the Utilities Commission approves or disapproves costs?
Sorry, I'm required to answer this question?
Answer it, I'm sorry.
You're asking him whether or not he asked his counsel?
That's what I'm asking.
That's still inappropriate.
Well, she's sustained your objection. I'm making an offer of proof. So I'm a preserve, you understand that. I'm making an offer of proof, so it's in the record what the answer would be in case we have to take this someplace else.
Give Ms. Holt just a moment to respond.
May I explain what I've done? So while she's thinking about it,
Yeah, please
Yes, yes.
explain what you're doing.
you made my question was whether or not this witness, talking about the consultation with the public staff, asked legal consultation with the public staff as to what the standard was under which the commission allows or disallows costs. And she sustained your objection. I'm asking, create a record here as to what the answer would be had it not been objected to, ask for an offer of proof so that the answer will be in the record to the extent I take it up to some other level.
Well, ask him if he knows.
I did ask him that. No, I'm not asking about the
Ask him-
consultation. No.
Why don't
Listen,
you-
I've asked the question.
Ask him if he knows whether or not the commission's position on.
Well, I may ask that at a subsequent time, but
Do you want to ask the question again, Mr.
no,
Finley?
ma'am.
Okay, you want to continue with your offer to prove?
That's right.
All right. And Ms. Holt was contemplating whether she had an objection to that.
You've already sustained her objection.
Okay, excuse me. All right,
You've already sustained her
Okay.
objection.
all right.
What
Thank
is
you.
the
So-
purpose of the question?
She's already sustained your objection.
Then
So
Pros- Mr. Finley, then proceed, and the witness will answer to the extent he knows.
did you consult with your attorneys and ask them what the standard was for allowing or disallowing costs that the company seeks to recover in a general rate case? Did you ask them that question?
I object again.
All right. We're just going to take just a 5-minute break for just a minute, and I'll see the council up here at the bench for just a minute. We're going to go off the record for just a minute. And if it's agreeable to all the parties, we're going to move along from this line of questioning for now, and we'll come back to it at the appropriate time. So for right now, Mr. Finley, please proceed with your next line of questioning.
Mr. Hauser, you do not cite any cases, do you, in support of your opinion that the decision the commission should enter into on this issue should be based on the fairness as concluded by you as the engineer for the public staff?
No, but I believe the case cited by the company of Glendale Water in their rebuttal testimony outlines the removal of non-compliance, costs related to non-compliance.
Well, that's exactly what I want to ask you about. In your testimony, you do not make reference to the Glendale Water case, do you?
I do not.
Had you read the Glendale Water case before you filed your testimony?
I'm going to object. That calls for legal conclusions, and council can brief the discussion of those cases as they relate to the facts of this case.
He just talked,
Excuse me.
he brought it up himself.
Okay, excuse me. The question was, had you read the case, the Glendale case? And the answer would be yes or no.
Not beyond what's included as a citation in the rebuttal. Not beyond what's included as a citation in the rebuttal.
All right. Let me, since you brought up Glendale Water in the rebuttal, let me read to you several paragraphs from the rebuttal, page 13, line 28. Flip over there.
Line 28.
Yes.
Sorry, 13 line 28 is a citation on mine.
Yeah.
Okay.
Let me read it. The distinction between this case and Glendale Water is that there is no finding in the other litigation brought against the company or admission by the company in that litigation that any violation actually occurred. No intervener introduced evidence in this case that any violation actually occurred. Witness Junus's testimony that the company's legal expense for state litigation of coal ash complaints resulted from violations is based on DEQ's reports of groundwater exceedances and the fact that DEQ sought SOCs to address seeps in the Allen, Marshall, and Rogers Cliffside stations, both of which Junus interprets as compelling evidence of DEQ's violations. Transcript, volume 26, pages 730 to 31. The commission determines that the facts of this case are distinguishable from Glendale Water. Litigants settle disputed matters frequently for many reasons that are unrelated to the settling parties' underlying views of the merits of the dispute. Likewise, an SOC is a regulatory mechanism intended to provide clarity and certainty with respect to scope and schedule for compliance-related activities given a change of circumstances, such as a change in requirements or in operations. The company's willingness to enter into an SOC, therefore, is not premised upon an underlying admission of culpability. Furthermore, as explained by witness Wells, a DEQ report of an exceedance does not equate to a violation of environmental law or regulation. Mr. Junus attempted to expand the applicability of Glendale Water by applying its holding beyond the litigated facts of liability to include resolution of complaints that do not involve findings of liability and pending legal claims for environmental violations where there is compelling evidence of environmental violations. Transcript, volume 26, pages 729 through 30. The commission disagrees with public staff position. Glendale Water applies where there is a finding of liability, and the commission declines to expand its holding further. In addition, The commission does not find DEQ exceedance reports or SOCs to constitute compelling evidence of environmental violations. The commission determines, as it did in the 2018 DEP rate order, that entered into a settlement does not equate to an admission of guilt or wrongdoing. 218 DEP rate case, page 180. Conflating the existence of a settlement agreement or an SOC with an admission or other proof of guilt or wrongdoing is inconsistent with both the law and public policy of North Carolina. The North Carolina rules of evidence, for example, prohibit parties from using the existence of a settlement as evidence of liability. Likewise, in other matters before the commission, the public staff has defended the regulatory policy of encouraging reasonable and prudent settlement. Have I read that correctly?
Reasonably accurately.
You'll be happy to know I'm going to move on to something else. And I'm going to ask you about development fees.
Okay.
If you'll turn to page 31. Beginning on line 3. I'll read this to you, please. From the interconnection project costs, I reclassified the one-time $97,565 Harrisburg development fee as a planned in-service item with an in-service date of 2023. WRI was required to pay a one-time development fee to the town of Harrisburg in order to connect to their system. The development fee allows the company perpetual access to purchase water from the town of Harrisburg and should be non-depreciable. I read that correctly, didn't I?
Yeah, reasonably correct.
Well, I didn't mean to be unreasonable, but.
No, yeah, I'm just,
All right. Now, you do not testify, do you, Mr. Hauser, that the payment of the development fee to the town of Harrisburg for the interconnection was an unnecessary component of the project, and that without them, WRI could have made the interconnection and avoided issues with environmental regulations requiring it to have the two wells?
No, I think the development fee is necessary, but in this case, I believe that because this is a one-time fee, I do believe setting the asset as non-depreciable is reasonable.
So you do not testify that the fee was not an essential, just as essential in completing the interconnection with the town as the pipes, the valve,
It was
just a minute, the vault, the Zern valve, and the money paid to Ms. Hook to get the easement, and the money expended with DOT and other compliance aspects of the town of Harrisburg, do you?
it was necessary to purchase water from the town of Harrisburg.
Right. And you do not testify that the vault, the Zern valve, the cost incurred to hire the contractor for the installation of the cost, to hire the engineer, the cost incurred by Mr. Abbott and Ms. Lockwood, leading to the construction of the interconnection, are other than one-time costs, any more than the development fee is a one-time cost. You don't testify to that, do you?
I don't, but in the case where in the future, this interconnect would need to be replaced potentially after the life of the asset, the cost would need to be incurred again. So in the case of this particular interconnect with the town of Harrisburg, these are one-time fees. They will be completed in order for the interconnect to be placed into service in 2023. They would have had to incur those costs one time. But in the reality of, capital assets, at some point, it may need replacement. And in that case, the fees you will need to incur similar costs if you choose a similar project. You would need to incur that cost again. So in that case, in the narrow view of this project, yes, those costs were incurred once. But if the asset needs to be rebuilt in 50 or 100 years, then the costs that were incurred in this project would be incurred again, likely, in another project. So In the sense that the development fee paid to the town of Harrisburg is a one-time fee. You would not need to pay the development fee to the town of Harrisburg if you reconnected to it after replacing the plant.
Well, how do you know that?
I mean, I don't unless Harrisburg intends to charge them repeatedly for use of the interconnect that they've already paid a development fee for.
And you do not testify that the other cost of interconnection, in addition to the development fee, are costs that allow the company perpetual access to purchase water from the town of Harrisburg, do you? You don't testify that, do you?
No.
Are you familiar, Mr. Hauser, of the parable of the want of the nail?
Sorry, repeat the name?
Want of the nail?
No.
Oh, here it is. Add a little levity to the case. For want of a nail, the shoe was lost. For want of the shoe, the horse was lost. For want of the horse, the rider was lost. For want of the rider, the message was lost. For want of the message, the battle was lost. For want of the battle, the kingdom was lost. All for want of the horseshoe nail. Never heard that one before?
I have not, or I don't remember having heard it before.
Would you agree with me that for want of the development fee, the interconnection with the town of Harrisburg would not have taken place, and the ability to provide service to customers in the Rocky River subdivision in compliance with the environmental law would be lost?
You're asking if the development fee would not have been incurred if the interconnection had not taken place?
That's what I'm asking you.
It wouldn't, but in this case, the life of the interconnection fee payment should be perpetual, and the life of the physical Harrisburg interconnection will not be.
Now, you recommend depreciating the cost of the interconnection minus the development fee over a 50-year term, do you not?
Yeah, that's correct.
Now, as I read your testimony, Mr. Hauser, nowhere do I find where you cite a project comparable to the construction of the Harrisburg interconnection. Do you cite that?
I don't, but it's understood that ductile iron pipe typically has a life expectancy in excess of 100 years. And if you look at the application of Aqua North Carolina and sub 573, they include, I think it's exhibit NS, a depreciation study, which uses transmission main and distribution main as 58 years. And that likely includes plastic as well as all the other transmission or distribution system appurtenances, valves, blow-offs, things like that. And that's all rolled into 50 years. Given that this interconnect is constructed from ductile iron pipe and it's restrained for the entirety, my understanding based on the plans, I think 50 years is a reasonable amount and potentially short.
Well, it's got meters and it's got vaults and it's got valves and it's got telemetry and it's got all sorts of wires and it's is that the same thing as the example you gave from the Aqua case? Is that a different project?
I believe the transmission main distribution system is in, as a whole, their assessment of the systems as a whole, including the various components you and I just discussed.
It's comparable?
I believe so.
How much of the investment in the Aqua project is pipes?
I'm not sure.
How much of the cost in this project with the town of Harrisburg is pipes?
I'm not sure the construction explicitly lays out. I believe it's 140 linear feet. Sorry, I believe it's 140 linear feet of ductile iron pipe, but I'm not sure the costs associated with that component compared to the others.
And what about the cost of the Zern valve and the vault and the?
I'm not exactly aware of each single component's cost in relation to the entirety of the total project.
You finished? The answer? Can you give me other examples besides the one you gave as to where a development fee like this has been taken out of the total cost of a project in order to determine the depreciation expense?
No.
So WRI is a small company. It has been required to make major investment in the neighborhood of $470,000 for this interconnection with the town of Harrisburg that it didn't intend to make. And that clearly, those costs are clearly not being recovered in current rates and the rates that will be in effect during the period the steps were taken to complete the interconnection. That's correct, isn't it?
Yes.
And the investor in WRI had to come up with the money to make the interconnection. It had to wait until the interconnection was complete before it could come in and ask to begin recovering the costs. It had to incur all the costs to file the application, to undertake the expense of complying with the public staff data request, of going to the public hearing, or going to this hearing in the hope of getting some rate relief some months from now. And it's the public staff position that they should not be allowed to recover the costs of this interconnection for 50 years.
I believe 50-year depreciation life is reasonable given the asset, and they'll earn a return on their investment into the system.
So that, my math is not very good, but that's 2074,
Second?
2074.
Oh, sorry, the year of the depreciation.
Yeah.
Yes. Excuse me, the asset was placed in service in 2023. Sorry.
That's all right. Now let's talk a little bit about the cost of the bond. Went back to page 31, line 1. And you testify, I also removed legal fees associated with the proceeding to increase WRI's bond, which was founded by the public's, you do not, probably not the right word, but requested by the public staff due to WRI's noncompliance. That's basically correct, right?
Yes, that's basically what's written.
And again, you don't make any assertion in your testimony that the cost of complying with the commission's order was unreasonable or imprudent, do you?
In relation to the bond
Yes.
filing?
All right. Again, in your footnote 2 on that page, you refer to the DEQ requirements having to do with the second well, right? Bottom of the page down there.
Yeah, I'm looking at it.
So again, here we're talking about the bond that the commission requires in its order, and we're dealing with DEQ requirements again, are we not?
Yes.
So where do you discuss the disallowance of the pump?
That is in the plant and service page. It is on page 28.
Tell me what you understand about the facts of the pump costs, please.
I understand that in 2022, the company incurred costs to repair or replace a pump, which the company stated in response to data request 12 that it was a 45 gallon per minute pump, while the company is approved to use a 78 gallon per minute pump in their well number 2. and that the company incurred costs to replace or repair it. And in the following year, that same pump was replaced entirely from service. And so the pump was not deemed reasonable and prudent in the rate case. And it was not in service at the time of our review of plant service costs.
What do you understand the reason for the acquisition of this particular pump and the reason that it was taken offline?
During my site visit, I spoke with Mr. Abbott, and I was under the impression that this was the replacement for the pump, which at some point a pump was oversized and was being operated system manually. It sounds like I may have not recalled the conversation correctly, or the company is providing conflicting information, and that this pump was in fact undersized and wasn't able to actually meet the DEQ supply standards. And it's no longer used and useful following the removal of it in 2023 and the replacement.
Yeah. Do you understand that it was taken offline because it was hit by lightning?
I did not know that.
May I take a minute?
Yes, we'll go out, you want to approach?
No, just, yes, please. Like my notes, please.
We're going to go out the record for about 5 minutes. Thank you. record.
Mr. Howard, we were talking about house, I apologize, I get those consonants mixed up a little bit, so forgive me for that.
No, I saw that you had a client named with a similar name last week, so.
That's right. We're talking about the pump a minute ago. Isn't it correct that in the responses to the data request, it was indicated that the pump was removed because of a lightning strike?
The response to data request, I'm holding the data request 12 in my hand right now. The words it uses in response to question 3D are, there was no warranty on the pump. Based on a phone call with Reed Mullis of Gopher Utilities regarding the pump warranty, he stated that a warranty applies only if, quote, it was a literal act of God, semicolon, it was struck by lightning, so no warranty.
I think that was.
So the warranty applies only if it was
No,
struck
that's
by
fine.
lightning?
Well, we'll leave that to another day.
We can send you the email.
Let me ask you about, hey,
Let me just to clarify the record there. So the response to the question is the pump was taken out of service because it was undersized or oversized.
My understanding from what the company just says that the pump was taken out of service because it was struck by lightning. And the data response says that the warranty applies only if.
Yeah.
So my understanding based on the data response is that the pump should have been in warranty based on what it says.
company will be prepared to address that in greater detail.
Okay, thank you. Thank you.
So let's take a quick look, Mr. At page 25, line 19. The annualized costs related to repair of the piping in the filter building at Rocky River's well number 2 over a 3-year period to reach a reasonable ongoing level of expense. Given the magnitude and atypical frequency of this event, this type of repair should not be expected on an annual basis. What is your justification for your conclusion that pipe breaks of this magnitude don't occur with some regularity?
My understanding from Mr. Abbott's testimony is that during the time that the well was offline, there were only 3 events which led to service outages. One was this maintenance issue, and 2 others were line breaks due to fiber optic installers in the neighborhood. The customer testimony may not agree with that, but based on review of the Consumer Services Division complaints over a 3-year period, we received 7 complaints, 6 of which happened at the time of this issue. So I believe it's reasonable to determine that a break of this magnitude does not occur, and it only occurred once in the 3-year period. So I believe the annualization over a 3-year period is reasonable for this maintenance issue.
Those are the questions I have on cross-examination.
Thank you, Mr. Finley. Do you want to go back now to the offer of proof?
That's completely up to you.
Okay, all right, so we can complete that, that discussion. So we're going to go back to that discussion where you're wanting to ask the question to the witness regarding what he had asked his attorney about being reasonable and prudent. Public staff had objected, and I allowed it for the offer of proof, and I'm going to allow it now, just to reiterate, for the offer of proof. The witness will be able to answer the question from Mr. Finley, but it's only for the purpose of if the company is to appeal this decision of the commission. These responses will not be taken into consideration as part of the evidence in this particular proceeding that this commission will use to make its decision on the legal fees. It's an offer of proof for appeal purposes. So Mr. Finley can ask his questions. You can respond to the best of your ability, but your counsel will know it's not a part of this record for this decision making.
So the question is, did you ask legal counsel with the public staff whether or not the tests to be employed by the commission to disallow costs is whether or not those costs are reasonable and prudent, or are unreasonable and imprudent.
So
I'm just asking if you ask them that.
it's an industry standard that the benchmark for disallowance is reasonableness and prudency.
The specific question that we're talking about is, did you ask your lawyers whether or not that is the standard? Did you ask? I didn't ask you what they told you. I just said, did you ask that question?
I did not discuss that with them.
So there we go. That's it.
Okay, okay, thank you. Okay, redirect from public staff.
Mr. Hauser, counsel for WRI asked you about, different conversations the company might have had, that you didn't discuss in your testimony. Would the public staff be privy to settlement negotiations between DEQ, DOJ, and WRI?
No,
And basically, was the consent judgment, a result of WRI's non-compliance?
yes,
Was the amended consent judgment a result of WRI's failure to comply with the consent judgment and the subsequent motion to show cause?
yes, it was associated with continued noncompliance.
Okay. And in your investigation of this case, have you reviewed the DEQ DOJ complaint, consent judgment, motion for show cause, amended consent judgment?
Yes,
Yeah, did you review the direct testimony of Mr. Abbott?
yes,
Did you review the public staff's motion for increase in the company's bond?
yes,
Did you review the company's responses to the data request that the public staff sent?
yes,
Did this knowledge contribute to your understanding and recommendation in this case?
yes,
In your opinion, is it common for large projects to be broken down into specific plan accounts with discrete depreciation rates?
yes, I believe so.
Okay. Is it uncommon for capacity fees or development fees to be recurrent?
It's not common for a utility to incur a capacity fee or development fee multiple times.
Okay. Our council referred to your recommendation of a 50-year depreciation life of the interconnect. Are depreciation rates recommended by the public staff based on the financial capabilities of the utility?
No, they're based on the expected life of the asset.
Now, in terms of when we ask questions, sent data requests, did the company make additional claims in its rebuttal testimony when compared to its direct testimony, which necessitated additional discovery?
Yes,
The company made reference to data requests, and I think it would be prudent to offer that as an exhibit. For the record, I'm offering, as an exhibit, public staff data request number 12 dated May 2nd, 2024. And the subject of the data request, joint rebuttal testimony of Peden and Perry Consulting and Dennis Abbott. And I would request that this exhibit be marked as public staff redirect, public staff Hauser redirect exhibit 1.
And without objection, that will be so identified and marked in the record.
Mr. Hauser, let me direct your attention to public staff data request. I'm sorry, number 3. A copy kind of like
Sorry, I think our printers run out of ink.
DR 12, question 3. And I'll read the question. On page 20 of the company's rebuttal, the joint witnesses discuss the public staff removal of pump repairs from 2022. Regarding the pump that was removed by the public staff, please answer the following. What was the approved design pumping capacity? What was the actual pumping capacity of the pump that was repaired in 2022? Was the pump operating manually or automatically? And were the repairs which were completed in 2022 under warranty when the pump was replaced in 2023? Now, could you discuss specifically the company response to D?
Yes. The company response to part D was there was no warranty on the pump, and that based on a phone call with Reed Mullis of Gopher Utilities regarding the pump warranty, he had stated that a warranty applies only if it was a literal act of God. It was struck by lightning, so no warranty.
Okay, and what does that mean to you?
That the pump is under warranty if the warranty would apply if it was a literal act of God, that it was struck by lightning.
Okay. All right, thank you. Now, going to A and B, could you follow up on the difference between the company's response in A and B?
Yeah, so the approved design pumping capacity is the DEQ capacity approved for the pump in that well. In this case, it's well 2. The design pumping capacity, according to the company's response, that Jeff Westmoreland had stated that the approved pumping capacity is 78 gallons per minute with a 10 horsepower pump. So the response to part B states that a 45 gallon per minute pump was operating at the time. And given the utilities source issues where they're operating only on one well, I don't believe it's reasonable to be operating on a 45 gallon per minute pump when your approved capacity is 78 gallons per minute. In this case, DEQ requires approximately 400 gallons per day per connection. And this service area has, if you count the bulk customer connections, 131 connections. The math boils down to 0.55 gallons per minute per connection. And so a 45 gallon per minute pump would be insufficient. And this lends credit to the customer testimony at the customer witness hearing that there were significant outages on a potentially regular basis. And it seems reasonable to expect that that's accurate, given that the company for some amount of time was operating on a single source with an undersized pump.
Thank you. I have no further questions.
Okay, all right, I have a few questions for you, Mr. Hauser. Speaking about the pump that we were just talking about, that's on page 25 of your testimony, you say that you annualized the cost related to that repair over a 3-year period. I'm trying to understand your adjustment. When you say you annualized, did you look at several years of expense and normalize the level? Like, instead of annualized, you amortized it or kind of spread it out over a longer period of time? Help me understand what you mean by annualized.
Similar, yeah. So I looked at a 3-year period of customer service related complaints, and it appeared there were extremely high volume of customer service complaints at the moment that this or preceding this repair. And so based on that, a 3-year period of customer service complaints, it seems reasonable that this has only happened in one time in a 3-year period. Otherwise, we would have seen other similar spikes in complaints in the Consumer Services Division customer complaint report. And I didn't see that. So I believe 3-year period, sorry, I didn't see other spikes in complaints. And I believe that's a reasonable time period to spread the cost recovery out over, or the expense amount.
Okay, so you took a dollar amount of expense and divided it by 3 years.
Yes.
Is what you did. Where is that in the exhibits?
So I don't believe that's actually calculated in my exhibits.
Okay.
I'd be happy to provide a
Yes,
filed
'cause
exhibit of my maintenance and repair recommendation.
that would be very helpful because yes, we could not find that. We were thinking we were overlooking it. So it would be good to see what that total dollar amount is, how you amortized it, and how that fits in to your recommendation for repairs and maintenance. Okay. And following up one more time on the pumps, so is it your testimony that the pump that was taken out of service, that it's not reusable, that it is, it can't be reused at a different place or sold, that it's no longer functional?
The pump that was removed in 2022.
Mhm.
Yep, based on the company's information that it was struck by lightning, I would think it's likely not useful
Okay.
beyond
All
that
right.
point.
And what was the dollar amount of that pump?
That's actually not listed directly in my testimony. I think I'll include it as a
Yes.
late filed exhibit. It may be $14,500 approximately.
Okay, that would be helpful as well. Yes. Okay, and while we're talking about numbers, the legal fees, we're trying to determine where in the testimony is the breakdown of the adjustment to legal fees. Because, there's varying types. There's the legal fees related to the bonds, complaints, maybe some other legal fees as well. And this was in, I think, miscellaneous professional fees. But we really couldn't see the detail of that in the public staff's exhibits. If you could point me to that.
The legal fees addressed in my testimony are limited to the legal fees which were included in the company's plant and service cost for the Harrisburg Interconnection project.
Okay.
Other legal fees and professional expenses are included in the testimony schedules of public staff witness fees.
Okay, I'll ask her about those then. All right.
Would you like a table of the Harrisburg
Of
Interconnection?
the other ones, yes, the ones that were removed from plant in service, yes, that would be very helpful as well. that, yes, that you were talking about, in your testimony, that you had, quite a bit of discussion with, Mr. Finley.
Okay.
And I know Mr. Finley touched on this, how the public staff determined that one half of certain of the legal fees would be recovered from customers or recommended for recovery, tying them into the DEQ and reporting, commission reporting. But the question is, and I believe you answered, Mr. Finley, but I just wanted to be sure how you determine 50% or one half of the amount of that category would be reasonable.
So it is a removal of half, and the total amount that would have been or would have not been incurred had the company completed the project sooner is unknowable because it's not, you can't say, oh, this is the amount that would have been incurred versus this is the amount that had not. So it is 50% of the costs related to the interconnect filings and the compliance filings with DOJ, and 100% of costs related to the contempt filings.
Okay, and you do know, you do have those dollar amounts that you can provide in that
Yes,
Lakeside exhibit,
and
yes.
I'll include that as
Yes.
part of the Harrisburg interconnection legal fees.
Okay, all right. And on the development fee, the one-time fee, how did you obtain your understanding that that was the one-time fee? I mean, what documents did you look at?
The company included documentation the company included a table in their plant and service records
Okay.
showing each of the costs which went into that. And I believe it was 97,565 or 95 potentially.
I've got 97,565.
Okay.
So that was included in the company's plant in service records
Yes.
that you reviewed. Why was the number uneven or not like a flat fee? What was it? Is it some calculation?
I'm not sure. It's based on the costs paid to town of Harrisburg. So I'd have to review their schedule of fees. They do have a schedule of fees related on their website, which outlines what the development fee costs are.
That would be helpful to know.
Sure, we can potentially include a copy
Okay.
of that with our filing.
Do you know if that fee, that one-time fee, that the company's reported as an asset, that would be transferred to another operator if the system were sold?
Yes, in the event of sale of the system, because the asset is as recommended to be treated, as I recommended the asset to be treated as non-depreciable, the value of it would not decrease over time. So if another company wanted to purchase the system, the rate base would remain constant between now and then, and the company would recover at that time or be returned to the $97,565 associated with the development fee.
Okay, all right, that's helpful. All right.
Excuse me, I want to add a caveat to that.
Okay,
Depends on the
yes.
purchase price, of course, but it would remain rate base until then.
Okay, all right. Right. Have you had a chance to review the rebuttal testimony of WRI?
Yes.
Yes, and is there anything in there, that struck the public staff as information? Had they known when they wrote their testimony, they might would have said more or said additional, regarding, I'm specifically asking about the public staff's belief and view and recommendation regarding that WRI took all reasonable steps that they could, or should they have done something different, or taken additional steps? I mean, has anything changed from the public staff's recommendation as a result of reading this rebuttal testimony?
Certainly given, and I can't base your question solely on the rebuttal based on the cross here today.
Yes,
It sounds
include
like,
that as well.
I definitely reviewed a lot of information regarding the interconnection, and of course, not all of it can be placed into the testimony. It's, there's a significant amount of information that was reviewed to go into these recommendations. So yeah, potentially I would have expounded upon some of that.
Mhm. Would there be something you want to say right now based on what you've ascertained?
Yeah,
I'm going to respectfully object, Madam Chair, you're asking this witness to do sorry rebuttal.
Okay,
Uh, You just don't mean to be impolite, but I don't think that's quite fair.
okay, all right then, I'll keep going, all right? Then, anything that you would like to say, and I would not say sir rebuttal, but just, I guess I just want to know that you stick by your recommendation.
yes, and I believe regarding the interconnection that the company first learned of issues related to radium in their well one in 2018 when they first began pulling, I believe it was May 2018, they pulled their first sample, which was above the MCL that's currently available in Drinking Water Watch. I think it was 5.2 picocuries per liter. They pulled another sample in the fall monitoring period, that third quarter monitoring period, which came back and I believe it was 7.7. And only until they pulled a third sample at 10.2 did they exceed the MCL, which is a rolling annual average. And the company should have known in May of 2018 that there was a potential issue. And at that time, they likely should have been looking into it. It sounds like based on Mr. Abbott's testimony today that the well was previously offline and was required to be brought online by the company in order to perform radium testing. So it sounds like based on his testimony today that the company was already operating in non-compliance with NCAC 18C 0402G5, which is the requirement to operate two wells. So at some point prior to the issuance of the MCLs and taking the well offline due to radium, the company was not operating the well in compliance. And I think based on that, the company should have been looking for replacements much sooner than what it did. And I think there are a lot of delays in here that it seems like the company is repeatedly incurring delays. And I believe they could have acted quicker.
Okay, all right, thank you, all right.
I'm going to respectfully move to strike that answer. Madam Chair, this was not the public staff's position, that there was any imprudence or unreasonableness in the steps that the company took to take well number one offline and to replace it with the town of Harrisburg. So we've got a brand new issue here that was not known to the company when it filed its rebuttal testimony, when it prepared its cross-examination, and I just don't think that's fair.
All right, well, and Mr. Finley, the company will have the last word. So, so we'll leave that where it is for right now. Mr. Hauser, I just have a couple more clarifying questions for you. The company stated in their rebuttal testimony that they have provided some invoices to the public staff regarding some legal fees that were removed for 2021 related to the interconnection. Has the public staff received those invoices? What's the status of review of those invoices?
And can you refresh my mind on which, I know it's at the top left part of one of the page, or the top part of one of the pages. Could you?
Okay, yes. So I'll write down the page number. Let's see. And it's going to be.
Is it 20?
I'm sorry. Yes. Let's see. No, let's see. I'm sorry. Hold on just one moment.
I think it's 20 lines 3 through 6.
Okay. Yes, thank you.
No, I'm not aware of having received them. I don't believe we received them on the date of filing of company's testimony, which
Okay.
was April 29th.
Okay. All right. I was just wondering if there was an update on that. Okay. Can we talk about the website for just a minute? This is something that the company followed up on from the last rate case. And the company will testify to that in a few minutes with their rebuttal testimony. But as I understand from reading the testimony, the public staff has not included any amounts related to the website in this current case because It wasn't live as of the audit period that was going on. In its rebuttal testimony, the company states that it has provided or can provide invoices for payments made to date along with a proposal. Has the public staff seen any of that information?
Sorry, there were invoices provided to us for the website. There were, I believe we had 2 invoices for the website, and my understanding is of the moment the website, and admittedly I have not looked at it today specifically, is not currently functional. And I do believe that the website would be a benefit to customers.
Okay, all right, I will follow up with Mr. Abbott on that, on rebuttal and what the status of the website is. Okay. How much was the costs that were removed from this proceeding for the website?
The company's application did not include any costs related to the website. I understand that the invoices we were provided in response to a data request included 2 invoices for it. I don't know the total amount off the top of my head for the invoices.
Okay, so no amount, from what I'm hearing you, no amount was included initially, so you didn't remove any amount, but some proposed amounts have not been added in.
Correct.
Okay.
My understanding is that we did not add costs related to the website.
Okay.
Excuse me, Commissioner, Hearing Examiner
Yes.
Hilburn. Public Staff Witness Lynn Fiesel would have information regarding invoices received.
Okay, I will ask Ms. Fiesel when she gets up. Thank you. I think that, let me ask one more question. Mr. Hauser, are you the person who sponsored the adjustment to the bookkeeper hours?
I am not.
Okay, that would be Ms. Fiesel as well.
It would be.
Okay, all right. Then you get off the hook then. I think that's all I have for you until we get redirect here on or questions on commissioner questions. So I'm sorry, hold on just a minute. All right, Mr. Finley?
So in light of the hearing examiner's questions, Mr. Hauser, are you saying that the costs now that the company incurred to put in this interconnection with the town of Harrisburg some of those ought to be disallowed?
The costs?
The cost of the interconnection, the $470,000.
Yes, the legal fees, which I recommended.
I didn't ask you about the legal fees, I asked you about
The-
the cost of the interconnection.
The amount that you just referenced, the $470,000, I think it's $462,000 after an update to an invoice from landscaping. And that amount does include legal fees, which are the ones that my testimony discusses removal of. The total amount of the project without, not exactly sure the total amount of the project without the legal fees, but we did not make other adjustments with the exception of the invoices, which we did not have. We did not make other adjustments to the cost of construction or the cost. We actually included costs to evaluate alternate treatment options for the green sand filter. So we're not recommending any changes to those costs, just the legal fees.
You're not recommending, are you, that had the company made the interconnection sooner than it did, that the cost would be different? You've not testified to that, have you? Besides the legal fees. I'm talking
Yeah,
about.
with the exception of legal fees, I don't know what the cost would have been if the connection had been completed at a different date.
All right, thank you.
Ms. Holt?
Yes, I have one clarifying question. Mr. Hauser, did you recommend disallowance of the website charges or did Ms. Fiesel?
I don't believe I recommended disallowance of the website charges. I'm not sure if it was something that was recommended to be disallowed or just not included in the company's
Okay,
or in the public staff's recommendation.
thank you.
Okay, with that, Ms. Excused. Thank you. Thank you for your testimony today. Ms. Holt, you may call your next witness.
Okay, I'd like to first move the, admission of public staff Hauser redirect exhibit 1.
We'll pick.
Yes, and that will be, without objection, that will be allowed in the record as marked.
Public staff calls Lynn Fiesel.
Madam Hearing Examiner, how long are we going to go today?
Excuse me, we're going to go till 5 o'clock today. And then we'll start back in the morning at 9:30 if we do not finish, which I don't think we will. If you will place your left hand on the Bible and raise your right hand, do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. And if you'll also state your name and your place of employment for the record.
my name is Lynn Fiesel. The place of employment is North Carolina Utility Commission, public staff. Business address is 430 North Secretary Street, Raleigh, North Carolina.
Swear her.
Summary into the record.
Yes. I was gonna go over some introductory questions.
Yes, please. Proceed.
Ms. Fiesel, on April 12th, 2024, did you pre-file testimony consisting of 16 pages in question and answer format,
Yes,
an appendix and 1 exhibit?
yes,
Do you have any changes or corrections to your pre-filed direct testimony?
no,
If I were to ask you those same questions today, would your answers be the same?
yes,
Madam Hearing Examiner, I move that Ms. Fiesel's direct testimony be copied into the record as if given orally from the stand, and that her appendix and exhibit be identified as marked when filed.
And that, without objection, that will be allowed.
Ms. Fiesel, on April 26, 2024, did you file supplemental testimony consisting of 4 pages and 1 exhibit, Fiesel Supplemental Exhibit 1?
yes,
Do you have any changes or corrections to your supplemental testimony?
no,
If I were to ask you the same questions today, would your answers be the same?
yes,
I move that Ms. Fiesel's supplemental testimony be copied into the record as if given orally from the stand, and that her exhibit be identified as marked when filed.
Without objection, that will be allowed.
Ms. Fiesel, did you prepare a summary of your testimony?
yes, I did.
And I would like to pass out a copy to opposing counsel for approval.
Yes, please proceed.
Thank you. No objection.
Sorry, we don't have any extra copies, but I'd like to move the admission of Ms. Fiesel's summary.
That will be allowed without objection. That will be allowed.
Okay, the witness is available for cross-examination.
Ms. Fiesel, I wanted you to please turn to page 14 of your testimony.
I'm there.
All right, I'm going to read your answer beginning on page 10 so we can talk about it, please. The company included an estimated amount of regulatory expenses in its application. I adjusted regulatory expenses to include the actual rate case expenses and expenses reclassified to rate case expense and included an estimated amount for notices, printing, envelopes, and postage fees to be incurred after the evidentiary hearing. And then annualize the calculated expenses over a 5-year period based on my analysis of the frequency of the company's historic rate case filings. Additionally, I recommended that if the company's next rate case filing exceeds the 5-year amortization period, starting with the date on which rates become effective, in the present case, the company shall record any overcollection of rate case expense beginning the first month after the 5-year amortization period ends in a regulatory liability account on a monthly basis. I further recommend that the amounts be recorded in the regulatory liability account and be returned to ratepayers with interest based on the weighted average cost of capital in a manner determined by the company's next rate case. Should the company file a rate case before the expiration of the amortization period, any unrecovered rate case expense balance will be added in the new rate case expense and amortized over the number of years approved by the commission in that rate case. I've basically read that correctly, have I not?
Yes,
Now, you cite no precedent that you rely upon in making this recommendation, do you?
I disagree because both DEC and the DEP has willingly filed with the commission to put the over collection of the rate case expense in the regulatory liability account. So that is not, and this is not the first case.
And where do you cite that in your testimony? That was my
It's
question.
not in the testimony. But I did some research and found two DCDP rate cases as the commission order discussed the over collection of rate case expense over certain years.
And now you're giving us that information for the first time. We hadn't seen it before.
I can provide the final order for DCDP rate case as a late filed exhibit if you want. Okay.
And what was the, here we go again into something we've never heard before. What was the docket number of those cases?
Give me a moment, let me find out. DC docket number is E-7/1276. DEP docket number is E-2/1300.
What are the dates?
It's public record. I did not have the date here, but you can check it on the commission website.
My goodness. Madam Chair, I hope you can appreciate the dilemma this puts us in. We prepare for this case, we read what their justification for their adjustments are. There's no justification, and you come in and say, you don't have any justification, and then they start giving you the justifications that we're not prepared to address. I mean, that's completely irresponsible, in my opinion. I'm going to strike that last answer. The last answer having to do with the rate cases of these electric companies.
Ms. Holt, would you like to respond to his motion?
It's the company could have done its own research and found these cases.
Madam Hearing Examiner, we don't have the burden of proof on the adjustments that the public staff is making. They say that in one of their data responses. You could have gone and looked up to find the answer to this. They have the burden of proof on this, not us.
The company has the burden of proof of supporting its case, its application.
Yes, Mr. Finley, the company does have the burden of proof in the rate case proceeding. Your frustration and your comments have been duly noted. The witness has provided the docket numbers, and we'll just proceed from there.
Were those cases settled cases, Ms. Feasel?
Those were stipulations.
Stipulations?
And those cases discuss the over collection of rate case expenses and the period of how many periods it can be returned to customers.
Now,
And I can read some, if it helps.
I'm not asking you to read anything. I'm asking about your testimony, not all this other information you're coming up with. In your testimony here, which is all we've got rather cross-examination for, it's correct, is it not, that you haven't cited any precedent, but you're coming up with it after the fact?
The regulatory liability account to record the over collection of rate case expenses has been in service for years. So this is not the first case we recommend this methodology.
Do you say you say this is our recommendation. Do you say it's fair, it's unfair? You just say this is my recommendation. That's all you've said that I've read there, right?
Would you repeat your question like
The
completely?
question is, in the part of your testimony that I just read, you say this is the public staff recommendation. You don't say it's fair. You don't say it's something that the commission should approve. You just say this is my recommendation, don't you?
My recommendation is based on my opinion that it's fair and equitable to customers.
Yeah, well, you didn't say that in your testimony, did you?
It's by default.
Beg pardon?
It's by default.
By default, okay. Let's talk about the 3 years versus the 5 years. You would agree with me that for many, if not most, of the small water companies in the state, the amortization for rate case expense is 3 years as opposed to 5 years.
We analyze the years of amortization for companies on a company by company basis. So maybe some other company use 3 years, some company use 9 years, some company use 7 years. There is not one fit for all year for small companies. I estimate the amortization period for WRI based on my investigation of the historical tendency of how frequent the company file rate cases.
All right, do you disagree that, set it aside for the moment, just the facts having to do with WRI, probably the most often period for amortization of rate case expenses is 3 years?
It's not. So I can give a list of detail of how frequent the WRI filed rate cases from beginning to the end.
Well, I'll ask you to get into that in a minute, but that's not really what my question was. It's setting aside for the moment the facts of WRI. Would you agree or disagree that probably the most often amortization period for rate case expense recovery is 3 years for small water companies?
I disagree.
What is it? What is the
It's a
average?
4 years.
Not 5 years.
The company filed in docket W-1034 sub 2 rate case, that is the first rate case. The final order is approved on February 24th, 1998. The second rate case, the company files the W-1034 sub 4. Final order is approved in 2002. The years gap between these two rate cases is 5 years. The third franchise the company filed is W-1034 sub 6. Final order approved is January 27, 2012. The time gap between this franchise and the rate case is 9 years. The third rate case the company filed is W-1034 sub 8. Final order is approved is November 21, 2018. The gap between this rate case and the prior franchise is 7 years. The most recent one, sub 13, the company filed a rate case on December 29, 2023. The time gap between this current case and the prior case is 5 years. So the range is from 4 years to 9 years.
So the answer to my question is yes?
It's not.
What question are you answering? I didn't ask you about anything like that.
Your question is the most frequent year the company filed recase is 3 years. I disagree.
No, that's not my
It's
question.
from 4 to 9 years.
That was not my question at all. But could we please get the witness to answer the question I asked her with respect to companies other than this company was not for small water companies, perhaps the most frequently used amortization period, 3 years. I said, but not this company, the other companies. And she went through a litany of answers with respect to this company. And just please ask her to answer the questions.
Excuse me, I do
speech.
believe she answered the question. She said she disagreed with 3, and she gave you an answer.
Just for the clarity here, Ms. Fiesel, would you please just repeat your answer to Mr. Finley's direct question that he just?
Yes, I disagree with the 3 years amortization.
And what else did you say?
Uh,
Not what else you say, but you had a follow-up of how many years it is.
Yes. Yes, I will list that again. The first transfer case,
No, I'm sorry, excuse me. He just wanted you to answer, it's the average 3 years for companies other than WRI.
I mean, there are many small utility companies. Some has 3 years, some has not.
Okay.
So I cannot just average many utility company to 3 years.
Mr. Finley, is that sufficient? Okay.
Let's talk about now we can talk about this case, this company, and you are, with respect to the last rate case, you are aware, are you not, that WRI inquired of its lawyers to investigate at some length the notification of the filing of this particular case a number of years ago, are you not?
I was aware that companies are required to file some reportings based on the commission's order.
Well, are you aware or are you not aware that the company considered a number of years ago coming into the commission and asking for the rate adjustment to its currently existing rates before this case was filed?
Yes, I'm aware.
And in the meantime, well number 1 was taken offline because of excessive radium, and the company had to undertake the investigation and investment in the town of Harrisburg interconnection.
If there is anything related to well number 1 and whether it's qualified or not, I believe witness Hauser is the better candidate to answer the question.
Well, all I'm asking you is, do you know that company delayed coming in for the rate increase because it had to make the interconnection with the town of Harrisburg? That would have been a big expense. It would have taken a long time to complete, and that influenced the timing of their staying out before they came into this case.
I'm aware that the company is required to file the interconnection, which is what the company is waiting for to file this rate case.
I take that as a no.
And Mr. Finley, we're getting right on 5 o'clock, so if you want to, if this is a good stopping
This
point.
is a good stopping point.
Okay, thank you, thank you. So we'll just, we'll stop for this evening. We'll start again tomorrow, same time, same place at 9:30 in the morning, right here. So thank you all, and we'll see you tomorrow. And we'll go off the record.